Boom. How are people doing? Is everyone doing all right? Um, it's it's another Monday, which is always its own kind of thing. We gotta just kind of live through the first day of the week. It's always funny how the first day of the week is such an onerous one sometimes. So I hope everyone's doing all right. Hope everyone's got a refreshment, whether or not that's booze or is just something cool to drink. You know it's a good sort of thing to be doing there. Oh, and I see we've got a tug raid. Hello, everyone from the tug stream. It Hopefully people are having a decent day here. Hopefully people have got some snacks, got some so forth. I know people are going to be commenting about the lack of the tie there. I assure you it is packed. It's just in a suitcase and I haven't unpacked it yet. I gotta get around to that, but that's gonna take me a little bit. So yeah, I hope people are doing all right. It's People are asking how was my trip. My trip was okay. I'm gonna talk a little bit about WestJet and how much they suck, because given that WestJet has decided they want to screw me, I will make a make a we'll talk about WestJet and have some discussion about them, because yeah, I'm not super thrilled by that. But we've got a whole bunch of news. We've got a whole bunch of stuff there. Um, Still beats Air Canada? I don't think so. I see water until I can get my hands on caffeine. I have coffee, water, and snacks. That's great. I had sushi earlier, so I was feeling pretty good about that. Uh, Yay! Hi from Black Donnelly Country in Ontario with chocolate milk, coconut rum, and Bailey's. Good stuff. Um, Utah having a Coca-Cola. Nice. Um, we covered that one. Free the tie. I will dig the tie out when I can. Thoughts on my second visit to Ottawa? I mean, I didn't really see much of Ottawa, to be honest. Not a whole lot. Hot buttered toast. Nice. I'm at work. I'm sorry. I hope you can escape soon. Work on a Monday is tough. So Brian Driscoll saying, I hope it was a good trip. Wish I could have made the AGM. It was a good trip. I enjoyed it. My factum writing is still going on. I'm working on written submissions for court. I'm at about 8 pages. I have to clean those up. I also have to write about 8 to 10 more. Did Zora get her walk earlier? So for the people just joining us who didn't see this on Twitter, Zora was wanting attention. And then when I was too busy, she went and got her leash and brought it over and was like, hey, walk. So I waited until she settled down, and then we went and played in the backyard for a bit. So not exactly a walk. We didn't go anywhere, but we played in the backyard. She was having her little romp there. Tom Collins, nice. I enjoy Tom Collins. Kurt Eaton had said you should never meet their idols. That was absolutely not the case with you. Well, thank you. It was great meeting you in Devon and Ottawa. Sorry you had to miss the Battle of Alberta. I was worried because I was feeling pretty out of it when I was in Ottawa, to be honest, from the travel. So I was I didn't want to make. I was like, I hope I'm not coming off too badly, because content d'avoir pu rencontrer Sophie from Quebec. Nice. Was nice meeting you as well. It's all right. See, Sophie, chanceuse. Sparkling water in Calgary. Nice. Live crew now, replay crew later. Going camping. Oh, that's nice. I'm thinking later tonight I'm going to set up the hammock in the backyard. I'm not going to be able to go camping, but I might do some writing from a laptop in my hammock in my backyard, because just to settle out. So that'll be nice. Um, let's see. What color will the cover be? I think it's got to be buff. Um, there's requirements. You don't get to pick the color. I'm gonna have to go through the requirements again, but yeah, you don't get to pick the color. It's got to be done. It's got to be per the requirements there. You and your quick trips, Runkle. You're a traveling man. Yep. So that's a good way to motivate yourself to write. It kind of is. I'm gonna have to hunker down and get everything done there. Oops. So don't forget to e-file it too. Yeah, it's all gonna get done. It'll all get filed. It'll all get served. It'll all be fine. So all right, we've got a whole bunch of different stories to talk about today. A bunch of things have happened, some of which happened just today. So that's exciting. Um, I guess people wanted to talk about what happened with WestJet. So my experience with WestJet, because screw WestJet. WestJet, as they're an airline, they're not a super budget airline or anything like that. They're just they're a Canadian airline, and so I did my check-in online, and my online check-in was, I got the confirmation screen, but I always just send those confirmation, like the boarding pass email, to an email address I don't really use. And the reason why is because I just go to the airport and then print out a paper boarding pass. I much prefer having a paper boarding pass because if my cell phone runs out of batteries, the paper still works. So I much prefer that overall. So that was my game plan. But I went to the airport and I go to the little kiosks to print out my boarding pass, and it says, we don't have any record of your flight. And I went, you say what now? So I was sitting there like trying to figure out what the heck to do with this machine. I wandered down and used different machines. And so finally I'm just like, okay, I'm going to go up to the front counter there. And when I get up to the front counter, they're like, oh, you're too late to check in, or like, you're too late to check in. And I'm going, but I already checked in. Like, I checked in online. I saw the confirmation screen. Everything was good. And they're like, no, you never checked in. And I'm sitting there going, well, I'm pretty sure I did, actually. So they're like, nope. Did you want to book another flight? We have canceled your flight, and you have just lost that money. Now, it wasn't me paying for my flight. So, but it's still a piss off, right? Because even though it's not me paying for the flight, it's still frustrating as heck, especially because at this point there's half an hour left. And I'm like, I can just print me out a boarding pass. I'll just walk through and get on the plane. Like, this will not be a problem. But they're like, no, that's not possible. So I'm like, okay. So anyway, I then have to go in, and people are saying, I hope I had email confirmations. I didn't, because apparently it didn't actually do a check-in. It just gave me a screen saying confirmed. Like, I picked a seat and everything. So anyway, so they then say, okay, well, sorry, you're no good. And I'm like, okay, cool. I guess I'll book another flight, I guess. And they're like, oh, and you'll also need to book a flight on the way back. And I went, what do you mean on the way back? Like, I'm not late for the flight on the way back. Why do I have to book another flight for the way back? And they're like, oh, we canceled that too. So that is super, super frustrating. that they just canceled that. So now, I mean, I'm flying fairly often now. It seems like I've got a whole bunch of things, but yeah, I was really unhappy. I voiced that on Twitter, and Twitter basically said, "Hey, we, their Twitter representative is like, oh, sorry, you didn't like, this is all your fault." And I went, if this is all my fault, I'm like, no, I know that, I know what I did. I know what I didn't do. I know, like, this is, and like, I'm not getting into a fight with them over the money because it's not my money, right? It's not, somebody else is paying for all of this, including the makeup flight. So I'm just pissed off because WestJet sucks so hard. That's why I'm pissed off. So WestJet, you suck. And yeah, so we'll probably do some things mocking WestJet as we go, because that was a major annoyance. I still got into Ottawa, but I had to take different flights. They were slightly later flights, and so by the time I got in, I was just so tired that I basically had to head off to the hotel and kind of wind down. I popped in on Friday Night Frenzy for a bit, but yeah. Why did they cancel the return reservation? I don't understand that. The reason why is basically because F you Runkle. That's really what it comes down to. They're like, hey, if you if you miss the flight leaving, we're going to cancel the way back. Now, WestJet, so once upon a time, Air Canada sucked real hard. And WestJet came into existence to be like the friendly airline. They used to tell jokes on the plane. They don't do that anymore. They used to be like super friendly. They were, all of this. All of that has ended. WestJet is now every bit as miserable and depressing as any other airline could possibly be. And quite frankly, I'm just like, I don't see a reason to, I just don't see a reason to use them anymore. So Air Canada's actually managed to be more pleasant somehow. So yeah, and they're like, oh, well, you can contact Transport Canada to to make a complaint. Well, they know that Transport Canada is completely useless on this, and quite frankly, so that's why they're like, oh yeah, go to Transport Canada. It's like, great. So really, my only remedy here is to just tell everyone how much WestJet sucks. That's basically it. So you see, it's one round trip ticket. So if the outbound is canceled, the whole thing gets canceled. That's just the rules for the airline. Unless it's their fault, then they reprotect the return. It's still abusive as heck. Just because it's their policies doesn't make it okay. Doesn't make it fair. So yeah, we're gonna keep mocking WestJet. WestJet sucks. But yeah, airlines in Canada suck in general. It's true. We get absolutely screwed. The amount that we have to pay for air travel, people in the States are always just shocked at how much they're awful. And it's funny because I had to adjust going to Scotland. I actually decided to cancel one leg of my trip because I determined that it was actually going to be faster rather than take the last flight on my trip to skip that and take the train. And so I took the train. But when I called them up and said, hey, I need to cancel that last leg of my flight, the European airline wasn't really understanding why I would be worried about them canceling my return flight home. They're like, no, that's not a thing. And I'm like, yeah, that is a thing though. That That is how that goes. And yeah, WestJet overbooks flights so much people get bumped daily. That's pretty much it. Oh yeah, tell them how bad the trains are in Canada too, Ian, and expensive. If you are if you're in Europe and you're used to good trains, like where you can catch a train from, in my case, London, England, down to Glasgow, and there's like trains going every like hour, then you will be shocked when you come to Canada and it's like, oh, right, to go from Vancouver to Edmonton, there is one train a day. And if you like, if that time doesn't work for you, well, tough. And also, not just one train per day, but to get from London to Glasgow was like $100. It was not a huge amount. I forget what exactly it cost. It was not super expensive, but to get from Vancouver to Edmonton on a train is like $1,000. It's just ridiculous. So why don't people take trains in Canada? Because it's cheaper to fly. It's just straight up cheaper to fly. It's kind of sad because I would totally love to take a train, but yeah, they don't make that a viable thing. All right, so that's my rant about about WestJet, but let's talk about some other better things. And people should say, if you're in the chat, let's thank Mrs. Runkle, because Mrs. Runkle was basically like, this is a great day to go mow the backyard. And I was like, can we not? Because the window right there leads out to the backyard and is very poor sound protection. So the window, if she was mowing the backyard, and the backyard needs to get mowed, so I'll probably end up doing that later. But if she was mowing the backyard, all we'd be hearing right now is mowing sounds. So let's say a thank you to Mrs. Runkle for going, maybe not. And I was like, I recommend hammock instead. But yeah. All right. Somebody was saying that the try pricing Yellowknife to Edmonton. It's crazy for 1.5 hour flight. Yep. It is nuts. Absolutely. And somebody else was pointing out that the one rail line, I was thinking the Rocky Mountaineer, that one's 5,600. The cheap one is 1K. Yes. Yeah. If you want to get like a sleeper booth or something, then it's super expensive. My aunt and uncle took the Trans-Canadian Rail for anniversary, cost $3,000. Gee, ugh. I mean, it's almost cheaper to just rent a train car. It's not, but I mean, it would be funnier. That, I guess, would be one of the dreams one day, would be to rent a train car and like have it attached to a train and cruise around like that. But that is, I don't think it's cheap to rent a train car. So we'll have to just have to see on that. All right. Now, I guess we'll talk about some fun stuff there. WestJet claiming everything was your fault. Maybe they're sharing customer support staff with the Secret Labs tech support. Yeah, that sounds about right. All right. So I guess we'll do a swoop here, and then we'll talk a little bit about Mata v Avianca, because that's still a fun one. So there is the swoop. Somebody saying get a Shure SM7B mic. It cancels most ambient noise. That's a good thought. I've got the Samsung G-Track Pro is what I'm running. It does okay. So, all right. Ugh, need new swoop. I'm working on a new swoop. I am working on a new swoop. I haven't got the new swoop done. The reason why the new swoop is not yet done is because busy. I have too many things to do. Let me just see here. If I can find the right, I'm hoping to try to get like a Potter and Zora swoop, but we'll have to see. So, all right, Mara v Avianca. So, that is say because too busy, maybe inappropriate swoops for Rob. Um, I'll have to look at different swoops. Somebody said clowns, no clowns. So Mara v Avianca is now basically the this one is basically being known as the what do you call it? The Chat GPT case. The Chat GPT case is now what this one is all about, and this is such a ridiculous scenario. So a little bit of background on this one is that so the background here is there's a guy who's got a dispute with an airline of all things. How could somebody have a dispute with an airline? That never happens. Anyway, he's suing the airline. And one of the issues that he's having in suing this airline is a limitations problem. And what a limitations problem means is that you've only got so long to sue. Most places have a statute of limitations that says that if you're suing somebody, and possibly in criminal cases, you have a limited time to do it. Because, like, let's say somebody's upset about something I did in my 20s, they shouldn't be able to sue me for it now because, honestly, how would I defend against a case of something in my 20s, right? Where would I find evidence of that? I've moved houses several times. I don't talk to, like, most of the people I talk to are different people. It's all different, right? That life is so far behind me. So they've got limitations periods. Also, for like businesses, it only really makes sense to make businesses keep documents for a certain period of time, right? And if you had to defend against lawsuits 20 years ago, well, then you'd have to keep those documents forever. It would just be so difficult to do anything. So that's why we have limitations periods. So Mr. Mata's got a problem because he sued late, it looks like. At least that's one of the allegations. And so his lawyers had to solve a problem, which is there a way to extend that limitation period? There are things that will extend that limitation period, which is called tolling the limitation period. So one of the things that, as an example of where limitation periods can be basically paused, often if you're in many jurisdictions, if you're a kid, if you're a minor, like let's say somebody comes up to you when you're 6 and hits you with a bat and breaks your leg, and your leg never works right? You're always walking with a bit of a limp because of that guy who just out of nowhere came and hit you with a bat. Well, that would be, and I see Claude Simeon saying digital storage is cheap. The problem is that like memories are transitory. So that kid might say, hey, parents, you should sue. And the parents go, nah, we don't feel like it. In a lot of places, the limitation period doesn't start to run until the kid turns, till the kid turns 18. So that gives the kid some time as an adult to make that decision about that. There's other situations that can limit a limitation period. A big example of this is fraud. So let's say a malefactor, a mustache twirling villain, cheats you out of money, right? And they do it through some clever scheme. And you don't actually realize this for a long time. You've actually been so thoroughly conned that you don't realize it. Like, let's say they sell you an artwork, right? And you think it's a genuine, I don't know, Monet. And so you're thinking, I've got this Monet, it's worth tons of money. You hired an independent art valuator, but unbeknownst to you, that independent art valuator was also part of the fraud, right? They actually fed you the name of an art evaluator who was actually just the fraudster. So you did everything you could to determine that this was a real Monet, and you've been keeping it on your wall for 20 years thinking that it's a real Monet. And then finally you're like, you know what? I just want to, I'm going to sell this. And so you go to sell it. And now it gets taken to an auction house and they do an evaluation. They're like, sir, this is actually a fraud. Like, this is a fake. Now, you're going to have some issues with the auction house. The auction house is going to be like, you really wanted to get us to auction a fake, but you also want to go after that person that maybe you spent $1 million to, to buy this Monet. And he's going to say, you can't, because I sold that to you 10 years ago and you didn't sue me 10 years ago. And your problem, of course, is that you couldn't sue 10 years ago because you didn't know it was a fake 10 years ago. It was a fraud, right? And until that fraud is detected, you just don't know what's going on. So that is another reason why a lot of jurisdictions will pause that limitation period until you become aware of the fraud. Once you become aware of the fraud, like the day that you went and got told, this is not a real Monet, sir, it is worth no money. Yeah, that's a little torture. But, on that day, your limitation period starts counting. And so, you still have to act quickly once you still have to, act and take steps, but you can't just, you can't use that time that it was undetected in a fraud situation. So that is, that's sort of examples. Now here, one of the arguments they wanted to make is their argument was, they said basically that this bankruptcy that Avianca had should pause that limitation period because you couldn't sue them in the bankruptcy period. And so this was the argument that they wanted to make, and so that they were thinking of making. So what they did is they sat down in ChatGPT and they told ChatGPT to make that argument for them, which is a real problem, because what they said is, we thought ChatGPT was like a search engine, and instead it's actually just a making things up engine. Because ChatGPT, if you don't know how ChatGPT works, ChatGPT doesn't actually, it doesn't know anything. It doesn't have any ability to actually know anything. What it does is it has the ability to provide blocks of text that it thinks you will like as the reader. So ChatGPT is great for situations where you're just using it for giggles, right? You just want to hear what ChatGPT has to say. If you were watching on Friday Night Frenzy and you saw Rob's generated like dating profile in legal text, that is a great use for ChatGPT, because all it is it's fun text, right? That there's no harm to it, no anything like that. And but if you actually need for the information that ChatGPT is generating to be correct, then you've got a problem, right? Then you've got a real issue. And we can think about this like Midjourney, because if you are going on Midjourney and you ask it for, like, I'm going to ask Midjourney for an image of, I don't know, let's see, what's a fun one? Who's in the news right now? Let's see. I'm just trying to think of the name there. What is it? I'm just going to look for unidentified serial killers. We'll just pull things up here. Here we go. We'll go with Jack the Ripper. That's a good one. Because that's, maybe Fossaville serial killer. I don't know if it'll even give me this. Maybe I'll try Jack the Ripper because it's more likely to give me that. Jack the Ripper v5.1. So I'm asking it for the 5.1 data set, and I'm going to ask it to give it to me in 69. And it says that it thinks it might be against community standards, but it approved my appeal. I'm doing this live. So we're just pulling this up, and it's going to give us an image of Jack the Ripper. And it's going to take a minute here, even though I've got it on fast mode. I see. Of course he went with serial killers. What else would I use? There's not a whole lot of other people who are sort of unknown people, which is really what I want. What I want for my example here. Hey, Ian, I'm in the U.S. and bought an acre of land that, well, believe it or not, we can't build on and no recourse. Talk about a loss. Ooh, I am sorry about that. Maybe you can put like animals on it. I don't know. I don't know. That's rough. All right. We're going to talk about this as well. All right. So it's generating some images, and a couple of them have faces on them. That's what I'm looking for. All right. Just pulling up images here. Here we go. This is, now that one's holding a knife weird because Midjourney doesn't know how that works. All right, so we're just going to save that image, and then we'll try uploading it here. Brand. Overlays. Add entry. Sorry, I'm doing this live because I'm an idiot, but I should have planned my analogy out earlier. So, here we go. This is what Midjourney gives me for Jack the Ripper. Now, I mean, that's a face, right? That could be what Jack the Ripper looks like, but it almost certainly wasn't. This is just Midjourney AI coming up with something that maybe, that looks like how people have maybe drawn that kind of thing. So, yeah, that's the kind of knowledge that we're looking here. We're looking at stuff, where it just generates something that seems about right, but doesn't actually have any connection necessarily to the real world. So this is the problem that they ran into, because this guy then turned around and submitted a bunch of case citations that were made up because they didn't actually exist. And then the other side, this is funny because he didn't then go and check any of the case citations that he was using, which is stupid because as a lawyer, if you've got a, as a lawyer, if you're relying on a case, you should have read it and looked it up and all of that, but they didn't. But the other side did. The other side looked it up and went, we can't find these cases. They don't appear to exist anywhere. So then the judge tried to look it up, and the judge had the same problem. So they said, hey, where are these cases? You need to bring these cases. And here, I'm going to say at this point, if the lawyers had stopped here, if they had stopped at this point, I think that they would be fine right now. I think that they would be okay. But they didn't. What they did instead was they made a really, really terrible mistake. This is where this is a really, really terrible mistake, which is that they filed an affidavit saying these are real cases. And that's where I think that they got into some real problems, because once they filed an affidavit saying these are totally real cases, and how did they decide that they were real cases? Well, they went back to ChatGPT and they said, ChatGPT, I love you, ChatGPT. You're so helpful. Surely you weren't lying to me, right? And ChatGPT says, no, I am totally truthful. I am being honest to you, dude. Now I'm just gonna say, this is like the guy who, this is actually something that happens all the time, actually, with like Nigerian scammers. The 419 scams. And Nigerian scammer is actually at this point the name of the scam, because they could be coming from all over the place. But for a while, so you've got somebody who's like, dear sir, I have $1 million or like $600 million, and I need your assistance to do some trivial task, but you need to send some money first. And they start sending money. And then there's always some new thing that requires more money to be sent and more money to be sent. And then people, like their family, starts going like, where's all your money going? No, that's a fraud. And so what do? They go and they ask the fraudster, surely you're not lying to me, right? Now, the real problem here is that as a lawyer, you've got a real heightened obligation. As anybody swearing an affidavit, you have an obligation to be certain that you are, that you're telling the truth in that affidavit. Which is why you sometimes have to phrase things carefully in affidavits. You'll say things like, I believe this to be true because I'm informed from so-and-so, or something like that. But that is, that's something you got to be very, very cautious with, in these sorts of things. So it's a headache there. So you've got to be really, really careful with your affidavits. And there are some interesting things going on in this particular case. So if you were watching Emily D. Baker's stream, you will have seen she went over in more detail than I probably planned to. Unless people want me to. If people want me to go through all the filings, we can go through all the filings. But there are some really interesting filings in this one that I just don't understand. I don't understand what the heck is going on here. So let's talk about some things that I just that I don't understand. I see people saying do it. We'll look at some of the more recent things, and then if people still want, we can go back and look at some of the other of the other dumb. All right, so let's look at some new dumb, because this is big dumb, so much dumb. All right, we are going to have to embiggen. All right. So, this is an affidavit in support of motion for leave to file a proposed amicus curiae brief. So what this is that somebody who is entirely uninvolved with this case wants to submit an argument. They want in on this. They saw this dumpster fire and they were like, I got to get into that dumpster fire. I need to be in this dumpster fire because maybe there's like a box of donuts in there. Maybe there's something good in this dumpster fire. I got to get in there. I want in the dumpster fire. And I'm going to tell you, as another lawyer, I don't want anywhere near this dumpster fire. I want to be way the heck away. In fact, what you're not seeing here is Avianca, after they sort of said, hey, what the heck? They haven't done anything since. They haven't been like, we need further involvement. They're like, Judge, you got this. We're good. But this is somebody who's like, I want in. I need to be in this dumpster. I need it so bad. And so, yeah, Gregory C. Belmont wants in the dumpster. Pursuant to 28 U.S.C. Section 1746, he hereby declares under penalty of perjury as follows. This is how he wants to get into the dumpster. I make this affidavit in support of my motion for leave to file the attached proposed amicus curiae brief, the brief, and my claims the brief conveys are useful and timely information that will be helpful to the court and explains my interest in the order to show cause. I have no personal knowledge or relationship with the attorneys subject to this order to show cause, the parties, or any of the counsel. This is actually important because as an amicus, he's coming in as friend of the court, right? And so a friend of the court should theoretically be a neutral party. That neutral party is somebody who is saying, hey, I don't have a dog in this game. I just want the court to get it right. So that's what they're sort of looking for there. Now, I'm just pulling up something quickly here because now this is really gonna make you just shake your head here. All right. I currently reside and operate a legal AI software business in Newark County, New York. Oh, you can see why he's interested in this, right? I studied computational neuroscience and the rudimentary technical antecedents to the large language models powering ChatGPT as a doctoral candidate at the Massachusetts Institute of Technology, have worked over a span of 30 years in broadly related technology and science fields, and have been an active private investor in technology companies. The active private investor just tells us he's got a financial stake in this. This is not a good move. So I've spent approximately 1,000 hours since November 2022 using an engineering software incorporating the GPT platform. Okay, cool, neat. I founded and invested in one of the first businesses which employs OpenAI's ChatGPT and related software technologies, GPT platform, to perform litigation analysis services to attorneys, and for which I've spent over 300 hours this calendar year applying the GPT platform to litigation-related processes and interacting with attorneys practicing in the Southern District of New York about the use of generative AI technologies in legal practice. I wrote the amicus curiae brief. Relatively small portions of the prose were reviewed by various generative AI software applications, including my own, to improve expression and clarity. Any and all mistakes and inaccuracies are mine. I received no funding from any party. I would have probably just not done any AI on this one. I would have just said there's no AI used in this at all. Because, yeah. Or, I mean, here's the flip side of that, is that he's saying, hey, AI is so great, but also I'm not using it to file my own material. That's weird, isn't it? Like, if his AI is so good, why is he writing this himself? And I don't think 1,000 is a lot, but it doesn't sound like those hours are going to be documented or real. 1,000 hours is less than somebody might spend on a murder trial. So 1,000 is not a whole lot. It sounds like a whole lot unless you're in the legal profession. In which case it sounds like, oh, good for you. You started, like, you've just started. All right. Let's keep going. All right. So this is, we're going to, I don't know why I said stop sharing and not just took it down. All right. Am I drinking a lime Corona? I'm drinking a lime and cactus Corona, and it's not very good. So, whoops. 2,000 hours is 1 year of 40 hours, 40-hour weeks. I don't know when the last time a lawyer worked a 40-hour work week is. So that's 25 40-hour work weeks, or about 6 months of full-time work. Yeah, lawyers are often working like 16-hour days on some of this crap. So let's have a look here. Yeah, this is actually a really mediocre drink. Corona Tropical Lime and Cactus. Mediocre. In my state, a cosmetology license is 1,500 hours. Yeah. All right. So, proposed amicus curiae brief in support of court's consideration of order to show cause. So, interest of the amicus curiae, so why he's going in this, and technology background. We're going to, have a look at all this, but it's, he's got some opinions. He's got some notions as to what's going on here. So, preliminary statement. Gregory C. Belmont, on behalf of himself and his fully owned business, Sarah Bell Legal Intelligence, Sarah Bell, respectfully submits this amicus brief to support the court's consideration of its sua sponte order, etc., 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 for variously, directly, and indirectly citing non-existent cases and submitting non-existent judicial opinions attributed to the use of generative artificial intelligence software application ChatGPT to conduct legal research. Cool. It says, indeed, the instant order to show cause has generated enormous media coverage and public interest. We got interest, right? We got interest. I see people saying, scrap that drink and find something yummy. I'm on a live stream. It's hard to, it's hard to scrap the drink and find something yummy. So the OSC may be the first action in which generative AI is the subject of controversy and has motivated at least 2 standing orders in other districts related to use of the technology. To the extent the subject is found by the court to be typical and innocent on the one hand, or careless and irresponsible on the other, and the related degree to which sanctions are too severe or too lenient, could potentially chill productive and responsible use or further stimulate development and adoption of these technologies by legal practitioners. Why does he care about? Oh, right. This goes directly to his business model. This guy is terrified that the court is going to say, you are being this is incompetent, and that people are going to stop hiring him for things. That's what he's scared about. Now, in this circumstance, I'm like, okay, I'm not super interested in your financial interest here. Yeah, I love generative AI, and this guy should be smacked hard by the court. Yep. Lucky Logger is actually pretty good. Lucky Logger is decent. We have to buy Runkle a small beverage fridge for his office. I had one, and then I moved it out to the garage. All right. So, they say this is especially so since sanctions resulting from this are to be limited to what suffices to deter repetition of the conduct or comparable conduct by others similarly situated. We're going to talk about how others are similarly situated because, yeah. Now, personally, if I was working on legal AI stuff, you know what the last thing I would want to do right now is? The last thing I would want to do is to get the name of my company possibly attached to this decision. This is the guy jumping into the dumpster fire. It's so bad. So bad. Like, hey, I want to be, because what's a possible outcome here? Well, a possible outcome is that the court writes a decision where they specifically mention Cerebell now. That's a possibility here. And they could specifically say something like, notwithstanding Cerebell's promises about all of this, we actually think that, that it would be unethical to rely on Cerebell's technology based on what they've said. So that would be, yeah. He wishes to claim the dumpster fire as his own. He might move that flaming dumpster into his living room thinking that it's going to keep him warm. And instead, it's just going to burn his house down and smell like garbage the whole time it does. So, yeah. Yes, but does he file my ancestry tree guy bad? Not quite, but we'll talk about that too. All right. Providing information about the market context, including messaging by the media and the software's developer, the user experience produced by the software, accessing excerpted records of content generated by the software, and the full capabilities and weaknesses of the technology when used responsibly. So, interests of the amicus curiae. First, his livelihood is closely associated with the software attributed to error. This is also a thing that I would not want to put down myself in a filing. Hey, our product sucks in the same way their product did, is kind of how that reads to me. So I wouldn't have wanted to file that in this. So Cerebell provides an interactive interface that enables attorneys to utilize secure versions of the GPT platform in a manner highly comparable to use the eponymous ChatGPT application, but with the added benefits of privacy, citation guardrails, TM, and ability to augment queries with litigation case files in a process referred to as retrieval augmented prompting. So the degree to which sanctions are or are not issued in this matter will impact the public's, the legal practice industries, and the wider judiciary's perception and evaluation of ChatGPT and related software, including the amicus's, which are broadly perceived as one and the same as the application consulted by the subject attorneys. I can tell you there is no way that I would be wanting to use anything around generative AI at this stage. I would want to see some generative AI that actually, maybe was able to back itself up. And here, really interestingly, this guy doesn't have his generative AI doing his work. He says, it reviewed some things for clarity, but he certainly isn't having the generative AI write it because he's not that crazy. So yeah, he's saying that the outcome could affect his business. They say that he has the requisite expertise to provide timely and useful information to the court. So do you want to be called as an expert witness? He actually does, by the way. He actually says that he's available as an expert witness. So technology background, enabling deep neural network technology and large language models. All right, now this is going to get super technical and therefore super boring. We've given some summaries before about how this generates human-like text and provides a range of useful natural language processing tasks, including those at controversy in this matter. I would not call the output on this one to be useful output in this. I would not call this to be useful output. In fact, I would say it's the opposite. Training, text corpus. So it is able to learn from a bunch of digitized text, which includes a broad variety of topics, including law-related texts. Now, all of this is not super relevant here because the court has already found that this guy has submitted false details. And I'm just going to say the AI is not entirely the problem here. because had the guy gotten that, like submitted that AI generated filing, and then when it was being told, hey, you screwed up, went, oops, I checked it and these are bad citations and sorry, I'll redo it, I think he'd be fine right now. I think the court would just say, listen, you're going to pay some costs. You're going to pay some, you'll pay some costs for the fact that you've delayed this. We're going to give you another month to get, to actually do your filings. And then you're just going to do them over by hand, right? Like an actual person. So that would have been fine. Instead, what they did is they doubled down on it. Now, I'm going to say, if you took the AI out of the picture entirely, this case plays out exactly the same way it does. Let's say we take the AI out of the picture entirely, and instead we just cover, and Nick, yes, I will. We'll definitely get to that. So let's say you take the AI out of the picture entirely. And instead of using ChatGPT, he used a very senior, very respected lawyer at his firm, somebody with 30 years of experience, who is an expert in the field, who is just unquestionably somebody you should trust. And unbeknownst to him, that very senior, very respected lawyer has then developed a habit, like he's developed a side hobby. And that hobby is meth mixed with alcohol, mixed with cocaine, because he's just decided to really go full bore. So that lawyer writes a piece that is complete gibberish crap. That lawyer makes up citations because he's flying on meth, right? Even though he is a lawyer who is otherwise somebody to be, respected. So, at that point, you're in the same place of, hey, I submitted this based on something I thought to be reliable. And the other side says, this is actually bad. If you went and said, we checked it now and it's crazy, then the court would be fine with you. They would say, okay, we understand. We understand how you got here. We understand that there's a problem. You can fix it. Good for you. Where he gets into trouble is in the doubling down. So if you go back to meth lawyer and you say, hey, meth lawyer, did you make up those citations? And he goes, no, man, and sucks on the meth pipe. And you say, okay, good enough for me. Then at that point, it's on you, right? You had actual notice that you needed to do some checking yourself, right? And you didn't. So in this case, we've got the meth lawyer and, it's the same scenario. It's not ChatGPT that's the problem entirely. The problem is that having gotten unreliable information, he doubled down. He put in an affidavit that it was okay. And that is his... that's where we get into some real problems here. So, all right. So basically, he's here saying, don't cause problems for the meth lawyer industry. All right. So, was it large language models can also be made conversational and positioned as chatbots? All right, carrying on. Launch an iterative development of ChatGPT, which it just keeps going in terms of the history. We don't really care so much about the history here because the history is not super relevant. Capabilities. Natural language can be categorized as composition, fiction, composition, nonfiction, coding, conversation, search, summarization, editing, translation, classification, and sentiment analysis. While all of these are accomplished by synthesizing strings of words, the later 5 typically constrain output to provide a text and therefore may not be considered under all definitions as strictly generative. Okay, so these are different things it can do. So both forms of generative AI offer benefits to the legal community, among others, time-saving efficiencies with demonstrated ability to streamline writing processes and, in the right circumstances, and especially with the addition of value-added layers provided by companies like Cerebell. I'm just going to say, maybe don't toot your own horn too hard in the amicus brief. Quickly analyze some complex legal issues, such as identifying potential discrepancies in testimony. I would never rely on, at least I can't say never. I would not, under the current state of affairs, rely on ChatGPT to identify the potential discrepancies. I might get it to look over some of them, but I would go through everything and do it myself anyway, because, under the right use cases, LLMs can enhance the overall quality and reliability of legal documents. Maybe. So basically, he's saying our software is useful. So they say the text generated by LLMs, since they're not driven by traditional faithful databases or prescribed rules, can range from eerily precise and accurate to extremely random performance compared to a stochastic parrot or blurry JPEG. Frequent problems include hallucinations, confident errors and false confidence, seemingly plausible statements with no contrary indicators, variance, different outputs from the same prompt, bias, reflecting any in the corpus, such as, to some critics, prevalent cultural hegemonies, errant reasoning, and very rarely jumble. While not shortcomings in their utility, open legal questions not directly relevant to the issue and controversy here include potentially open or unresolved open issues related to possible infringement of copyrights. Guys, this basically, his own statement here basically says you should be really careful about using this in a courtroom. This paragraph is basically why not to use it. So legal context basically says the more legal content you put in there, the more likely the output will helpfully mirror authentic citations or harmfully comprise a de novo text that only resembles the format of legal content while depicting fictional judicial citations or opinions, artifacts referred to as hallucination, or perhaps more precisely, hallucitations. Okay, that's interesting. So basically, all of this is saying this is not very good. This is not very spectacular. Legal safety measures. Part of the safety alignment measures engineered in ChatGPT pertain to the inclusion of disclaimers. So basically, there are warnings that say, hey, don't actually use this. And they note that there were upgrades that actually warn you that any citations, legal citations, may actually be fake. They've actually added that specifically. And yeah, this is a good point here. Sounds like he's trying to say this can be useful. Please do not nuke the entire industry when you sanction this idiot. The thing is this idiot deserves to be sanctioned hard. Real hard. So, and I'm just going to note, there's all sorts of other situations where, helpful tools can get you into, these kinds of situations. Like, if autocorrect changes a word, you might be responsible for that word if it goes into a contract. These kinds of things. So, yeah. This is entertaining. A user-generated database of legal prompts and conversational chat session transcripts that illustrate the type of legal research that can be effectively performed, along with instructive bloopers, is being made available at this webpage. Instructive bloopers. That is, let's maybe pull that up in a bit. So, belief citations and judicial opinions generated by ChatGPT were bona fide may not have been unreasonable at the time of consultation. That seems really interesting. So he says that the belief that these were bona fide may not have been unreasonable when he looked at it. This is complete crap, because no matter who provided you this citation and judicial opinion, you're signing your name on it. You are signing your own name to it. That is saying that you... so even in that case of the respected lawyer who then takes on the meth habit, you're signing your own name to it. You should have done some checking. And some of these checks should have been real obvious that they were just fake. He could have just plugged it in and said, hey, I want to see this citation. Like, I want to see this case. But he didn't actually do that. So, yeah. ChatGPT gained an extraordinarily wide user base, fanned by wide hype and praise in general and technology press, including among members of the bar. Your lawyers, you hire a lawyer because they actually are careful, that they are diligent, that they check this stuff out. So, yeah, that's one of the reasons to hire a lawyer, is because they check this. Oh, hey, my replacement chair thing is starting to disintegrate. Wonderful. All right. So just, they just note this might be the first time that work product consisting of text produced by generative artificial intelligence software is being evaluated for evidentiary value. And the more complete impression provided by the longer printed transcripts compared to the partial screenshots demonstrates the higher weight the court should accord them. Evaluating partial screenshots of partial transcripts is analogous to providing a partial bank ledger or partial deposition testimony. Yeah, I can agree with that. That's fair. But sanctions must focus on conduct, not enabling tools. What is it? If this court determines that Attorney Schwartz had a good faith belief ChatGPT performed the function of a traditional legal research service, or could not envision the possible generation of a non-existent court opinion, the conduct here is akin to an error that could be produced by any headnote lawyer, which Black's Law Dictionary disparages as a lawyer who relies on the headnotes of judicial opinions rather than taking the time to read the opinions themselves. And UCLA should have been distinguished, I guess. Law professor Eugene Voka modernized as a chatbot lawyer. Although Northern District, I have no... That sentence is real bad. I wonder if that's a sentence that is the... I wonder if that's the sentence that the AI generated. That's a really hard sentence to read through. All right. Although Northern District of Illinois Magistrate Judge Gabriel A. Fuentes describes a presumption that a Rule 11 certification represents a presumption that filers have read and analyzed all cited authorities to ensure that such authorities actually exist, emphasis added, the court might consider the degree to which it is common and accepted practice for the actual reading of all citations to depend on factors such as relevance and volume of cited authorities, certifiers' familiarity with the cited authorities, and dependence on legal research tools, colleagues, law clerks, and / or paralegals. Yes, let's do that analysis, guys. Let's do that analysis. Let's have this real... let's have a look at how this analysis goes. So, yeah, maybe you don't read every case. Maybe you're in a hurry. And so you only read the cases that are most relevant to you. Well, these cases were his entire point. These cases were his entire... he lives or fails on these cases. So if we're looking at the relevance, these cases are incredibly relevant. There is no excuse for not checking these ones. So the next one is, certifiers' familiarity with the cited authorities. Well, he can have no familiarity with the cited authorities. because they don't exist. You can't be familiar with things that don't exist. Like, I am not on a first name basis with Tinkerbell because Tinkerbell doesn't exist and is not a person. And so, yeah. And dependence on legal research tools, colleagues, law clerks, and / or paralegals. You're filing it. You're filing it. So, yeah. Court must consider the effect of sanctions on the bar. I actually think that this guy's submissions might actually go the way he doesn't want them to go. This might actually cause him some problems. Second Court has found that Rule 11 sanctions can have the effect of dissuading counsel from engaging in ethical conduct that is deemed in the best interests of clients if sanctions issued to third-party attorneys create a threat that attorney conduct could be construed as improper by associating that conduct with penalties. So counsel defending an alleged trademark infringer were sanctioned for their client's submission of a fraudulent document prior to their appearance, and even though their client was untruthful to them. And I'd agree with this. I would agree with this 100% if the court and opposing counsel hadn't put him on notice that these cases were fake. Because that is the thing, right? Like, I do criminal defense. I will tell you, my clients are not always the most honest people. Sometimes it happens that they're not, right? I might be defending somebody who is literally accused of fraud. I might be defending somebody who has like 16 prior convictions for fraud. I see people saying that you can't deny the fairies exist. I'm not denying fairies exist. I'm denying that specific one exists. So, so if, and this is the thing, it is entirely possible that I might accidentally file a fraudulent document because my client has lied to me, right? I try to ensure that that isn't the case. But I can tell you, if I filed a document and I filed that document and, you know, let's say it's got a letter from this guy's employment or employer, right? It says this guy works for me. And, you know, he's a great worker. I will take him back anytime. Love this guy. Please let him out on bail, right? And so, like, let's say I take that document, and now my practice when I get a letter like this is to call the guy whose name is on the letter and to be like, hey, is this letter, does it exist? Right? But let's say this guy has his buddy, and his buddy, like, you know, let's say they perpetuate an elaborate fraud on me to get me to file this, right? So if I file this document and then the Crown prosecutor comes back and the court comes back and says, hey, this company that your guy says he works for, it doesn't exist. At that point, the steps I'm taking are not just, well, I asked again and he said it exists. The steps I'm taking are, you know, more thorough. That's the problem here, right? It's not just that the guy got screwed by some bad information. I mean, he should have known it was bad, but like, that's not the problem. The further problem on this one is that having got that information, having got that update, what does he do? He doubles down. That's where he gets himself into real trouble. That's where he gets himself just absolutely... That's where he goes completely off the rails here. All right. So Circuit Court found that the objective unreasonableness standard was too severe for a sua sponte sanction, and that it was necessary to find the least stringent possible standard to apply under the rules because the majority reasoned Rule 11 sanction regimes can have the effect of deterring legitimate actions. And what are the legitimate actions that he wants? Could have the effect of dissuading attorneys from adopting technologies similar to those used by the subject attorney that promise to increase the quality and efficiency of counsel provided to clients. Such apprehension would harm the amicus's livelihood. Now, I'm going to just go ahead and say I don't think the court here is really going to care about the amicus's livelihood. That said, if I was the court, I would say, listen, we're not here to dissuade people from using AI or whatever, any tool that works, but you are responsible for what you submit to the court, and you need to go over it. You need to check it. And that is always the case. So, and yes, I'll just remind people, if you're here, hit the like button. It's very helpful to the stream. I see we've got 1,000 people watching and 608 likes. So let's see if we can get those numbers up. All right, let's, what is it? I'm guessing he's of a certain demographic of U.S. men who are completely unaccustomed to having to admit they made a mistake. I mean, lawyers should be good at admitting they made a mistake, right? Lawyers, this is an important skill set for a lawyer. I'm saying not until you admit Tink is real. All right. Hit the like button if you think Tinkerbell is real. All right. So, responsive standing orders of 2 other district courts demonstrate that directives could form a harmful precedent by motivating non-constructive judicial rules. So they're saying other courts put in rules that are really, really bad here. And what are the rules? The judge-specific requirement, which permits use of Gen AI, while effectively imposing a financial tax on doing so. Use of a traditional legal base database or reporter, most of which are expensive, prohibitively so for many pro se parties, and the largest of which are commercialized by entrenched providers subject to credible antitrust claims. So all he said, so his standing order basically said you need to, if you use generative AI, you have to check it with traditional databases. You have to check your work to make sure that it's accurate. That is entirely fine. I don't see that there's an actual problem. I actually think that this amicus brief is is getting itself in some trouble here. All right. So there's a second order, which recognizes AI as a tool for legal research and drafting. And so they do explicitly allow Gen AI, but they imprecisely stated judicial requirements to vet the tools may pose compliance headaches that dissuade use and inhibit vital experimentation and education. Attorneys should be trusted to make choices concerning how they practice and represent their clients, and legal tech vendors should not be unnecessarily impeded in efforts to win their trust. I am sorry, guys, but all the court said is you are responsible for checking everything over, and you need to certify that you are not submitting BS. And the reason why they send that is so that they can drop the hammer on anybody who's like, I didn't know. The court is going, you're on notice. You have to check on that one. So, yeah. Further concerns about opt-in certification. So discriminatory to include selective brand names and not general description of product or service provider categories. He's upset that he got left out. Prejudicial to one set of tool providers, traditional legal databases, over generative AI models. Sir, we're not at the 2-hour mark. I should have waited until 2 hours. Sir, sit your ass down. Sit your ass down here about prejudicial to one set of tool providers. Traditional legal databases are greater than generative AI models. Because they are. Because they are. Traditional legal databases contain actual cases that exist, like real things. Whereas the generative AI models are generative. They are creating stuff from nothing. And so, no kidding, it's prejudicial. This is like saying it's prejudicial to say that you need to do your legal research out of like legal case books and not the Wizard of Oz. This right here is why tech bros need to be like sprayed with the hose until they realize that they are, oh my God, oh my God, oh my God. Sit your butt down, sir. You are just annihilating your own case. Annihilating your own case. Tech bros, man, they're just. Ugh. All right. Redundant recapitulation of Rule 11, other federal rules of civil procedure and rules of professional conduct, while not being least restrictive way of. Again, the AI, if this is the AI, like, is this the AI's work or his work where it's generating these sentences that just don't work? While not being the least restrictive way of achieving compelling court interest, a warning notice clarifying interpretation of Rule 11 obligations might be. I mean, the court's got a fair bit of flexibility on this one. Only 4 mentioned use cases: form divorces, discovery requests, suggested errors in documents, anticipated questions at oral argument, amount to endorsement by court of a restrictive list favoring named task types over others, for which platforms can demonstrate at least equal utility. Hallucination criticism disregards many productive and responsible uses which do not tend to hallucinate, such as ab initio tasks comprising information augmented prompts, e.g. summarization tasks where generation is restricted to provided texts. I wouldn't rely on a summarization task either. I would say that a lawyer who just used summarization is also like who just summarized a case with an AI and didn't actually read it, because I can tell you, I tried some of the summarization. I tried some of that, and I will tell you that what some of the summarization did was it generated completely wrong statements. It actually got the case entirely backwards because it misinterpreted negative statements. So, yeah. Asserts Gen AI doesn't swear an oath, where neither do headnote writers, legal reporter editors, or executives of multinational legal research database companies. Okay, fair enough. Criticizes Gen AI for bias, yet traditional databases have also been found to have bias. Yeah, I guess. I mean, there's different aspects as to, what cases make it in there and so forth. All right. So basically, law tech innovators are demonstrating how automation can benefit the administration of law, lead to more efficient and equitable resolution of legal issues with fewer court proceedings to few up resources to focus on matter where human judgment is most indispensable. Talk about the law as code thing. I can tell you the law as code movement can probably go to heck. So burdensome opt-ins to use lawful advocacy tools improperly asserts courts in the role of advocate by influencing how attorneys choose to plead for their clients, potentially depriving representative parties of the utility, productivity gains, and cost savings associated with these powerful technologies. Yes, it is influencing them by saying you have to check your work. So neither sanctions nor courtroom rules should preempt legislative action. Basically, it's saying that there's going to be legislative action that will, decide on all this. Okay. Discipline conduct, not the tools. I mean, they're going to discipline the lawyers, right? That's how this goes. So the use of technology doesn't diminish the importance of a lawyer's judgment, understanding of the law, and the ability to advocate for their clients. So irrespective of the tools that they use, you've got to be competent. Yeah. Conclusion: be mindful of the potential impact of sanctions, which basically means impose minimal sanctions because that would, cause us some problems. I just don't get it here. I do not get this. Like, why would you sign on this? Why would you want to? So now, this one has been, we've been at this one for a while. Did people want me to look at the previous filings in this case? Emily went over some of them. We can go over them again if people would like, because there are some things in here that I'm just like, why? Can the court sanction an amicus curiae? They probably won't. The courts will probably, instead of sanctioning the amicus curiae, they will just say, we don't consider it helpful, and we are going to, we're just going to toss them. All right. I'm seeing mostly people saying next case, new topic. I kind of agree. Sorry, Kestrel. I think you're outvoted on this one because, yeah. But that amicus brief, it just, I don't get it. All right, let's pull up another document here. We'll just get this going. Let's close all these Mata v. Avianca windows. Boom. All right, our next thing that we're going to go over is... Oh, and I got to swoop, and I got to... let's go through some super chats. There's not a whole lot, but we'll go through them just while we are here. Swoop. All right. So first, let's go over memberships and member chats. So Angie Torres, thank you for 10 gifted memberships. Much appreciated. Sandra Ramirez, thank you for another 10 gifted memberships there. Pants, thank you for 5 gifted memberships. Janny Wallace, thank you for 5 gifted memberships. Much appreciated. Pants, work in 90 minutes, playing in the machine shop. Ooh, that sounds fun. Brentwood Chic, thank you for 10 gifted memberships. And Secret Labs customer support was saying that only happens if you're sitting wrong. I don't know what it is about these chairs, but I will never buy another one. So yeah, they just fall apart like nobody's business. I just don't understand it. All right. So also some super chats here and some memberships. Arvin Life, thank you very much for the membership. It's much appreciated. Bridget Oster, thank you for the YouTube membership. Much appreciated. Janny Wallace saying, dropping in, this is Mugly his hell here in Scotland to say hi. Hello. I hate muggy weather. Muggy hot weather is brutal. We were talking about WestJet and how it's bad, but not as bad as Flair. Is Flair the one that is also WestJet? Because one of the different ones is actually just WestJet. Oh, and hey, we got Rob in the chat. Hey, Runkle of the Bailey in chat, or hi chat. I'll be along shortly. Loud tools at the moment. That is fair. Loud tools are loud. Angie Torres, thank you for another 5 gifted memberships. Sorry I'm late, or I'm sorry I'm late again. It's all right. We're all good here. Rosalind Duke, because I adore you. Thank you so much. It's much appreciated. Stephanie 1208, thank you very much for the YouTube membership. It's much appreciated. Rhineman YYC, Runkle needs a central beverage fridge with an air tube delivery system to his studio and shop. Call me. That actually sounds really cool. I would love to see I would love to build something like that. I have no idea how I'd do it, but like something with the like the old timey vacuum tube where it goes shook and then like slides down. That would be amazing. Did you watch the end of Lawyers and Dragons to see what happened to the Gimlet pumpkin? I haven't been able to. That is something I want to do. I don't know when that will be possible. I'm gonna have to do it before next Saturday, certainly. But I don't know what happened yet. So if somebody wants to tell me what happened to the the Gimlet Pumpkin, I'm curious. I'm gonna have to go watch it, but yeah, I haven't watched it yet. All right, we have some new what is it? New developments here. So the one of the new developments is in the Afro Man case. Oh, and we got to swoop again. Swoop. There we go. All right. So this is Sean D. Cooley et al. Versus Joseph Edgar Foreman. Joseph Edgar Foreman, also known as Afro Man. Plaintiff's memorandum in opposition to defendant's amended joint motion to dismiss and motion to strike plaintiff's amended and supplemental complaint. Whew, that's getting to be a bit of a mouthful. That is getting to be a bit of a mouthful there. What is it? Pumplet got left behind while the group took off somewhere else. That's not good. That's not good. I will have to check that out, but that's concerning. Nope, Gimlet will be okay because if he doesn't have a sort of meat wall there, that'll be concerning. All right. Introduction. The defendants and the amici supporting them argue that the First Amendment to the United States Constitution and Article 1 of the Ohio Constitution require dismissal of plaintiffs' claims on free speech grounds. Much of their argument focuses on the special protection afforded political speech in general and criticism of government conduct in particular under the U.S. and the Ohio constitutions. So that is important. But there is no constitutional protection for the deliberate publication of known falsehoods that cause reputational damage. What are the known falsehoods? Because you did raid his house. And you did kind of eyeball that lemon pound cake. I don't think he took any lemon pound cake. You did search through all of his stuff. So, yeah. Nor is there constitutional protection for the several forms of invasion of privacy alleged in the First Amendment and supplemental complaint, hereinafter complaint. Defendants' passionate and high-sounding defense of freedom of speech is, in this context, a red herring. Is it, though? Is it? Plaintiffs do not seek to stifle criticism of government action. You do, though. You do, right? That is exactly what you're doing here. Nor do they seek to squelch satire, humor, and artistic expression. Again, you do, though, right? That is kind of what you're going after. As the allegations in the complaint make clear, plaintiffs only seek to protect themselves from unlawful defamation and invasion of their privacy. Well, then why did your claim, sir, start out saying that he'd stolen the value of your likeness? I mean, this claim is really evolving here, isn't it? Really evolving. As the following discussion will demonstrate, the complaint alleges facts that are sufficient to support each of the claims set forth therein. The defendant's amended joint motion to dismiss and motion to strike plaintiff's amended and supplemental complaint should be denied. All right. Legal standard. As defendants acknowledge, the bar for granting a motion to dismiss under the rules is high. The court must accept all... Oh, crap. We're going to have to go back to... we're going to do this, and then we're going to go back to ChatGPT. I forgot there was something I wanted to cover. So we'll go back to ChatGPT after this. There's more to cover that I haven't covered yet and that I really wanted to. So we're taking a ChatGPT break to cover some Afro Man. And Rob is sitting there shaking his head somewhere going, Runkle, get it together. All right. The court must accept all factual allegations in the complaint as true and must make all reasonable inferences in favor of the non-moving party. Then, in order to grant the motion to dismiss, it must appear beyond doubt that the plaintiff can prove no set of facts in support of his claim which would entitle him to relief. Argument. Count 1 of the complaint states a claim for unauthorized use of the individual's persona. Defendants argue that their statements regarding the plaintiffs were made in connecting sick So sick here basically means it's a quote, but it's a quote that is you're quoting something that is stupid. You know that it's wrong, but you're quoting the wrong thing. Now, so yeah. With the defendant's music are therefore opinions and art. Defendants cite no authority for this defense, and there is none. Well, I mean, some statements are just obvious. Um, so there is no exception in the statute or in case law interpreting it for unauthorized use of an individual's persona for purposes of art when the art is in essence a commercial advertisement for products. I'm just going to ask here, what happened to what you were just saying about this being a defamation issue? Is it a defamation issue, or is it a that they're stealing your valuable persona? Using someone's persona for commercial purposes is not excused by wrapping it in music, dance, poetry, or any other art form. Making fun of something in music is certainly pretty common. Like when Eminem, what is it? When Eminem goes and, has a diss track, or any other rapper has a diss track, that's not using someone else's persona. It's just a diss track. So the statute prohibits the unauthorized use of an individual's persona for commercial purposes under certain circumstances that you are nowhere near, right? That you are nowhere near. Your persona has to have value. Where's your persona's value? All right. The statute does include exceptions, however. Oh, good. We're getting to that. Thank God. An individual's persona can be used without authorization in connection with any news, public affairs, sports broadcast, or account. This exception is obviously intended to protect news organizations in the reporting of newsworthy events of public interest, or just people who are reporting what happened to them. When it says that it protects an account, like an account of what happened, then, I mean, that's what that's about. Oh, we're going to just pull this one up right away. Torin3 saying, have to get some sleep, but wanted to thank you and Rob for helping to push me to 740 subs. Got to do some CNC woodworking this weekend, so happy here. Guys, if you haven't checked out Torin3's channel, he's the person who made, where is it? This, which is really super cool. Let me get right in here. I just don't want to put it in my drink. Check it out. It is wonderful. His videos are wonderfully calming to go and watch. When I'm doing something, I've been working on my my legal writing here, and as I've been working on my legal writing, I have been checking out, watching some of his videos on occasion, just having them as something in the background, because it's calming. It's and it helps me. It's better to have something to listen to, so they're fantastic. Check them out. I'm seeing people saying embiggen. Okay, we'll do further embiggening. All right. So check out Torin3 and, his videos. All right. Let's get him to 1,000. Get him to monetization. All right. The complaint provides specific examples of many instances of use of plaintiff's persona that are clearly not news, public affairs, sports broadcasts, or other such accounts. I mean, everything is a reference to the events, right? Even the shirts. Paragraph 23 of the complaint includes links to 10 separate Instagram posts depicting the use of plaintiff's images to sell products. None of these posts purport to be reporting on the so-called raid of defendant Foreman's home in any way. They are simply advertisements designed to make money from the unauthorized use of plaintiff's personas. They're designed to make money from the mocking of you guys, right? From mockery. It's not, they're not putting your images up there because they're saying, hey, everybody loves these cops so much that they will totally buy something with their face on it. That's not why people are buying those things. They're buying those things because they want to make fun of the cops, right? That's what that's about. All right. After the initial complaint was filed, Foreman doubled down on his unauthorized use of plaintiff's personas, as shown in paragraph 25 of the complaint, subparagraphs A through G. Again, none of these posts even pretend to be news or accounts of newsworthy events. They're simply crass uses of plaintiff's personas to sell products by mocking you by specifically referring to events that happened. Defendants focus exclusively on songs and videos made by Foreman, many of which are not even mentioned in the complaint, and argue that these constitute art or music or accounts that are protected by the First Amendment or specifically exempted by the statute. But the complaint includes myriad examples, like those listed above, that are not even arguably art or news accounts. Defendants simply ignore these clear examples of unauthorized use for commercial purposes. I do actually think that was a weakness, and I mentioned this. I said that this was a weakness of the defense, that they didn't cover certain essential things that I would have wanted to cover. The speech contained in the examples set forth in count 1 of the complaint is not criticism of the government, as defendants argue. It is, though. Like, I don't see that this argument can fly. It's absolutely mockery of your actions as police force, as police members. So, yeah. It is simply the unauthorized use of plaintiffs' personas for commercial purposes and financial gain. Plaintiffs have alleged all of the elements of a claim under the code. You are missing one element that you... Now, let's just go over this. They bash the defense side, and they say they left out this, and they left out that, and they left out the other. You notice how they're leaving out the part of the test that says that their personas had to have had commercial value ahead of time? They're leaving that out because these cops cannot show that they had any commercial value in their personas before this. If they had never raided Afro Man's house, the value of their face for selling a t-shirt would be 0, right? How many people have bought a shirt? Just show of hands in the chat. How many people have bought a shirt that has the face of a random cop you've never heard of? Anybody? I'm not seeing it. So, here is what I would be trying to argue. Like, if somebody used my face, right? Because I'm a bit more of a public figure than those cops. If somebody put my face on something and started selling it, I would potentially want to bring an action, right? And if I was bringing an action, what I would do is I would then say, listen, I have been offered the following amounts of money for the use of my image, right? People have I'd bring in all the emails that I ignore where people say, hey, will you sponsor our VPN? Or will you sponsor our, Raid Shadow Legends? Or will you sponsor, this or that or any of these things? Those I think I could use to say, like, listen, people want to be associated with this persona. They're willing to pay money for it. And, that's some evidence, right? But we're not there. We're not, this is not a situation where these police were ever in that situation. Nobody was ever coming to these cops saying, hey, yeah. And this is sad. I know you like food that fights back. They aren't making surströmming anymore. I think it's just one. I think it's just Oscars. I think there are other surströmming brands that are out there. So, yeah. So this is, yeah. Defendants argue that the use of plaintiff's personas was primarily for the purpose of communicating information or expressing ideas. It was. The idea is, here are some cops that suck. These cops suck. That's the idea that was really being communicated. But the examples given in the complaint belie this contention. The primary purpose of most of the examples set forth in the complaint is clearly to sell products with the use and aid of plaintiff's personas. No, it's to sell products where people are buying the idea that you suck. Like, that is what it's. They're not buying this because of your personas. They're buying this because of the mockery. They're buying this because they're mocking you. The fact that defendants appear to be having fun with the subject and ensconce their commercial project in attempted humor does not change the fact that their purpose is overwhelmingly commercial. And the fact that their purpose is overwhelmingly commercial does not change the fact that it's free speech. It does not change the fact that it's free speech, right? Because most speech is done for money. I'm just going to tell you guys, like, I'm getting super chats doing this, right? People are subscribing to memberships. People, like, later on, I'll turn ads on and people will watch ads and I'll get money from that. This is commercial. I've got a shelf of books here. I can just go and pull a random book off the shelf here. Just a random, I don't know, what are we going to grab? What's a good one to grab here? Let's see. I don't know. That one's easy because it was sticking out. And it's got no cover on it. That's awesome. The cover fell off. This is How to Stay Alive in the Woods. That's the book I grabbed. I see somebody saying that doesn't look random. It was sticking out. So, you know. How's this one? A History of God. Random, you know. I'm going to guess that they sold this book for money. In fact, I don't have to guess very hard because if I flip the book over, let's just see. Can you read that? US $15.95, $23.95 Canadian. It's got a price tag on it, right? They're selling this book. It's still freedom of speech. It's still freedom of speech. Somebody's saying, is that the one by Bradford Anger? No, it's by Karen Armstrong. I've got basically a religious studies shelf over here. So I got a bunch of different topics. It's also next to the Complete Guide to Whiskey. So make that what you will. I'll have to put that away properly later. So the fact that it's commercial doesn't change the fact that it's free expression. So this fact is underscored by some of the posts that may not be by themselves constitute misappropriation. Where Foreman explains how he has profited from his posts. No kidding. You're allowed to profit from your expression. Lots of people out there do. All right. Nor is defendants' use of plaintiffs' personas incidental to commentary about police officers, as defendants claim. Plaintiffs' personas are at the center of defendants' advertising and marketing of the products depicted. The point is clearly to make money from use of plaintiffs' images and names. There's nothing incidental about it. The reason why your images and names are on there is because it's making fun of you, right? If I am saying that, I don't know, if I say George Bush is a dork, I'm probably going to have a picture of George Bush up there, right? You know, if I'm saying George Bush is a moron, I'm not going to put a picture of like a bush or a hedge, or, you know, I'm not going to put up a picture of some random dude on the street. I see people saying he paints now. Okay. I was just throwing him out as an example. I'm not trying to get super political. I was picking George Bush because he hasn't been a active politician in a while. So yeah, I'm not trying to make this into a political thing. I don't actually care much about George Bush at this stage in life. It was just, I need a name. All right. So, you know, defendants say finally that plaintiffs gave implied consent to the use of their images when they conducted the search of Foreman's premises. That one I thought was a little weaker. This is like arguing that an individual consents to the unauthorized use of their persona when she goes to work in the morning and is recorded on a security camera. There's nothing but going to work or executing a search warrant that implies acquiescence to the use of the video for someone else's private financial gain. But it does include that people might mock you, especially if your job is police force. If your job is police officer, then you have to assume that people might make fun of you online. And they might make fun of you online very successfully, right? Because you might accidentally pick somebody who's got name recognition and the ability to make a catchy song about how much you suck and how much you like lemon pound cake. So, yeah. Count 2 of the complaint alleges all of the elements for a claim of privacy by misappropriation, and motion to dismiss should be denied. States a claim for false light publicity. So they argue that count 3 should be dismissed because their statements were merely opinions and are therefore protected by the First Amendment. Again, plaintiffs base their argument on a selective and myopic depiction of defendants' statements. No doubt some of the defendants' posted statements qualify as opinion. Great, dismiss those claims. Plaintiffs do not allege that all of defendants' statements and posts are actionable, but many clearly are. For example, the statements set forth in paragraph 23 of the complaint are not only vulgar and crass, but purport to know something about the plaintiff that puts her in a false light and is untrue, as alleged in count 3. I think that was the claims of her being trans or her being a lesbian. Those ones, I was like, yeah, that's getting a little, you're losing the moral high ground there, dude. So that one I was like, come on. Thus, the example in paragraph 23K is sufficient alone to state a claim for false light publicity. However, that would knock out the claims for most people if that's the only one. But there's much more. All of the posts set out in paragraph 28A through F of the complaint are false statements, were known by defendants to be false, and would be highly offensive to a reasonable person. These are the claims about, for example, that the plaintiff stole Foreman's money during the search of the residence, that plaintiff Newman used to do hard drugs and snitched on all his friends, that the purpose of the search of Foreman's home was to kill me, and that plaintiffs attempted to kill me in front of my kids, and that plaintiffs constituted a hit squad to kill me in front of my kids. Some of those, I think, are probably still opinions. Some of these are running into some potential trouble. I said before, I was like, some of these comments I would not be super thrilled by. So, yeah. Such statements do not just cause hurt feelings, the type that courts do not want to bother with. In the current fraught social and political environment, such irresponsible and untrue statements are very damaging and even dangerous, as demonstrated by the many death threats received by plaintiffs in the wake of defendants' posts. I'm just going to say, this one is, I think that this is a weaker argument, but I think it's a weaker argument in part because I'm terminally online. And what I mean by that is that by virtue, I consider myself fairly well liked in the online sphere, right? Generally, people, I don't get a whole lot of, like, my chat is fairly friendly. There's not a lot of people trolling me and so forth. I still get death threats. And it just happens when your name is out there that, there are people who send me things about they're not happy that I own guns. And so they send me things saying like, hey, how would you like it if I came to your house and shot you? I'm going to come out to your house and shoot you. So, hey, welcome.
Hi, Ian.
How was sparring?
You get me super casual tonight.
Hey, nothing wrong with that.
Sparring was awesome, as always.
One of these days, if I ever make it out to your neck of the woods, I would love to see you compete, because I think that is the most badass thing. As hobbies go, it's a badass hobby.
It's fun. You should just come hang at the gym sometime. It's the coolest people I know I've all met at the boxing gym. So
I worry that if I got into something like that, I would walk out there and, I'd manage to get, hit in the head and get a stroke or something else. I just worry about that. I'm too much of a nervous. And then I go shooting, of course. But
Of course.
I guess it's just like the things you're comfortable with is where that
Exactly.
lands.
Exactly. I hate heights, but hit me in the head, no problem.
Yeah, well, I also hate heights. It's funny because I was running a wire from like, just to run an Ethernet cable. It's
Hmm.
probably about 8 feet up. Like, and I'm on this ladder going like, don't like this, don't
Yeah.
like this.
Ladders are the worst.
Oh, I'm just, yeah, that was stressful as heck. And and I'm sitting there looking down. I'm like, it's only 8 feet down. I'd probably survive this. But
Nevertheless,
nevertheless, um, have you followed the Afro Man case?
I have not. No, I just have barely heard about it.
Oh, have you seen the music videos?
No, no.
Oh, I can't
Are you
play
going to
them.
send me down a rabbit hole?
Well, I can't play the music videos here because of it's YouTube, and I will get a strike in a real hurry. But
Yeah.
so Afro Man, who nobody had really remembered for a long time, but initially did the "Because I Got High" song. You remember that one?
Vaguely, vaguely, it rings a bell.
So the police searched his house, and they searched his house looking for drugs and kidnapping victims. And
What? Based on a song?
based on apparently very little, they didn't find anything,
Uh-huh.
but he had security cameras all through his house. So he recorded this search, and then
Oh,
he's a musician. So he turns around and makes songs about this, which are mocking the police.
nice.
And he mocks
Nice.
them in ways like, hey, did you think that there were kidnapping victims hidden in my suit jacket pockets?
Love it.
And like, did you think that there were pounds of weed hidden in my CD cases? Like,
Yeah. Yeah. All the
so
stuff they tore apart for no good reason.
yeah. And he also alleged that a bunch of money went missing. And the police say we must have miscounted at the scene. And it was always the lower number. Like we oopsed.
Uh-huh.
Now, I will just note there was actually a recent Canadian case where the police say we oopsed and we miscounted the money. And the defense was able to get the case thrown out here because the defense lawyers they got money, they stacked it up, and they basically said, no, the amount that you say makes a stack that is so much smaller than the stack that's in the picture. The cops made a bunch of money disappear.
Oh, wow.
So it happens.
Yeah, it does.
So he then went on to make a bunch of statements about the police. He's selling shirts with their image on it to mock them. But he was also making some statements that go a little further than that. And this is where he might get himself into trouble. He said that the plaintiff stole his money, which I think that one's not going to be a problem because he's got a reasonable complaint as to money was not there. So I think he may, but he also says that one of the officers used to do hard drugs and snitched on all his friends, and that the purpose of the search was to kill him, and that they wanted to kill him in front of his kids, and that they constituted a hit squad to kill him in front of his kids.
Okay. So that hurt their feelings.
Yeah. But the question is whether those are stepping over a line that's going to be a legal problem for them.
Yeah.
But
interesting.
A lot of the allegation, like a lot of the things they're suing over here, are actually kind of ridiculous.
No, I could never have guessed.
They're suing over abuse, like of basically use of their personas for commercial value or for commercial purposes.
Okay.
So, like, there's a statute that prevents you from like making Kanye West shirts without Kanye West's permission.
Yeah.
And they're going, that applies to us.
Yeah. Interesting. Yeah, they have a similar law like that in California, the use of likeness. And I don't know that they have that in other states because normally it's just an issue of who's got the copyright. That's the person who took the photo. That's obviously him. So
Yeah.
that's quite interesting.
Well, I mean, a lot of places have like a common law aspect to that, where like if you, if you take a random picture of Kim Kardashian and put it on your cereal product or whatever,
Yeah.
that you'd get in trouble because it's like you're implying that she's endorsing.
Yeah, exactly.
But I don't know where they're saying that these police are actually like had a valuable likeness. Because I don't think anyone heard of these cops before this lawsuit.
They probably didn't want to be heard of, and they probably don't like being heard of now.
They really don't like being heard of now. So, yeah, we were looking at this one.
Oh, yeah. Unreasonable publicity given to private lives. Interesting.
Yeah. Now, this is where, this is some of the other comments he made that are a little crass. Foreman's postings that one of the plaintiff's voices is 3 octaves lower than mine. Someone should verify her, and that she might whoop out something bigger than yours. So basically, he's implying that she's trans. That is, that I think is a little overly crass. It's a little, but hey,
actionable, but actionable.
Actionable is the question, right?
That's pushing it to me.
Especially because it's kind of, I don't think anyone's going to look at that and say like, oh, this is being held as a truthful statement as opposed to just crass mockery.
Yeah,
right?
It's obvious hyperbole and just, exaggeration for dramatic effect. This is a piece of art, if you will.
Yeah, exactly. So they're going through, they've got a back and forth on this one. There's, so this is their opposition to a motion to dismiss that we're looking at.
Okay.
Oh, and additional fun. Guess who Afroman hired to represent him?
Marty Singer.
Bruce. No. Bruce Rivers, I think it is.
Oh, no way! Yeah. See, criminal lawyer. He's the criminal lawyer.
The stop self-snitching guy.
Yeah. So, good for him. That's awesome.
Yeah. Well, it's funny because when I started covering this, people were saying, oh, why did, how come he could play the videos and you can't? I'm like, he's maybe willing to take a little bit more risk on a strike. And then they filed something and it had his name on it. I'm like, that's why he felt safe not getting struck. Nobody's striking their own lawyer.
You hope not, but I've had some clients,
the stuff criminal clients will do at their own lawyers is epic. I remember one person who came in with a check, and I'm looking at their charges, and it's like 17 counts of check fraud. And I'm like, here's the thing. If this check doesn't go through, then not only am I not your lawyer, I'm a witness against you in the next file. And like, I'll probably be able to testify against you about the check you just gave me. And this will cause you all sorts of problems. So I'm just going to set this check down here, and I'm just going to look away. And if it's not there anymore, then, or maybe would you prefer to pay me a different way? They're like, yeah, maybe. I'm like, yeah, here's your check back. I'm not going to try to cash that. We'll take cash. Like this file will take cash.
Cash would be great.
So I ended up writing on the cover of the file, cash only from this client. Because, and then they came in.
Sometimes you just have to.
Yeah, they came in like, oh, well, will he take a credit card? No. No credit card, cash only, please. So, yeah, that's, and I see people asking who made the police report to begin with. I don't think that's been reported. I don't think we actually know why they ever searched his house because a lot of that never gets revealed.
Yeah.
So,
So I guess the search warrant affidavit has not been made a part of our record.
Not yet.
Yeah.
And they say, statements like the officer stole his money, that they intended to kill him, that they threatened to kill him in front of his children, that their purpose in coming to kill him are not vague, or nor are they opinion, but are set out of facts. I think that they can still be opinion.
I think they can still be opinion too.
Like, I think this person stole my money can still be an opinion, especially when the guy said there was money missing. There was an investigation that found a discrepancy in that. He can still have an opinion on that.
And things like they intended to kill him, it's like it's implied that it's an opinion because, of course, you're not in the guy's head. You don't know what his actual opinion is. You're just asserting it as your interpretation of the facts based on what you do know. So, I don't know.
Now, this is going to be interesting. The plaintiff's personas have commercial values sufficient to state a claim. However, their personas do have value because their names and personas are known in the community and beyond, both as public servants and private citizens. Not good enough, right? Just because people know you doesn't mean that it's valuable.
Yeah, exactly. Exactly.
As such, the persona...
recognizability. Oh, good Lord. And so, like, what, sponsorships have they ever gotten? I mean,
yeah, like, show me the sponsorship offers that you had. Show me which products, especially because I actually kind of suspect that police are not allowed to do these things.
Exactly. They're definitely not, and especially not in their capacity as police officers, which is kind of what this, seems to be about, personal digs aside, this is clearly about what they were doing as cops.
So they say celebrity status is not a requirement to recover, but they do need something beyond.
I exist.
I exist. Like,
people have heard of me. Somebody knows me. My mom loves me. I mean, Yeah,
it's Oh, and Roe versus Amazon.com. That what they're citing because they're saying that the engagement photograph of the plaintiffs was used by defendant without their authorization and had commercial value. Now, I'm just wondering. I'm betting. Now, I'm just wondering if Roe versus Amazon.com is referring to a specific person.
Well, it sounds like, I mean, just from what it's saying in this document, it sounds like it had to do with a commercial photograph, like a photograph that they had paid to be taken. You pay a wedding photographer or an engagement photographer or whatever to take these photos and edit them and whatever. So you could at the very least put that value on it. It has the value of what you had to pay to be able to get that photograph.
Also, it looks like that case was thrown out. So,
the Roe case?
Yeah, the Roe. So that seems they're quoting this, but ultimately that case was thrown out as not sufficient. So that's odd. And if I can find that in like a 5-minute Google search that your case law maybe isn't the most helpful to you, then that's a problem. They ended up saying the property right plaintiffs had in their photograph. Copyright, not that's a copyright issue. Oh God, no.
So they're just going all over the place with this one. They can't decide what their angle of attack is. They know they don't have a copyright argument, obviously.
Yeah, this seems really really weak. So, plaintiffs have alleged that the personas have commercial value. They provided no evidence from this, and they've adduced facts from which a jury could reasonably draw that conclusion. I don't think that they have.
No, I don't think that they have either. They're police. No. Not buying it.
I think, I've gotten sponsorship offers that I can turn around and say those sponsorship offers are an indicator that my persona has commercial value. But before I got sponsorship offers, even though I was known as a lawyer, I don't think that could ever have held up. Like, hey, I won at the Supreme Court. That doesn't mean that my face necessarily, like, that I have commercial value. Especially not on a shirt that's making fun of me. Because, like, a shirt that's making fun of somebody doesn't seem to be about their, persona for commercial gain. It's about making fun of them.
Well, and it does seem to be this equivocation where they're using this context like you described of sort of the false testimonial, type of scenario that it clearly doesn't fit in that.
And Bruce Rivers, there we go.
There he is.
Are you surprised?
In Minneapolis, huh?
And are you surprised to discover that he's got an AOL.com?
That's pretty awesome. He's old school. Bruce is old school.
He's old school. Actually, the lawyers on this one are interesting. It's a yahoo.com, AOL.com. And the only one that actually seems to have like a business one is we've got the ACLU. ACLU has their own, domain name, but everyone else is like yahoo.com and AOL.com. And yeah, so that's exciting. But you've been following Koberger.
I've been following Koberger. Yes, I have.
And you had a highly entertaining clip of what is it? Koberger. I can't tell if that thing's parody or not.
That's what I love about it. The media on this case is just gotten so ridiculous. It is so out of hand. And so when something that to my eye is like so obviously just this genius piece of satire, and yet the context is so out of control that you actually can't tell. I mean, that to me is the ultimate send up. It just says it all about this case.
Oh, I mean, some of the commentary on this one, I'm just like, you have got to be straight up just kidding me on this, because I'm just going to try to pull the video here, because it's, I think it's either brilliant satire or completely off the rails crazy town. And it's like, how do I know which it is? Because
well, there are some clues.
I feel like it's got to be the satire. It's got to.
Yeah.
I feel like I'm gonna have to like just scream and throw things if it's not satire. But I mean, and it goes into Rob's not here yet, so I think we can say it goes into the sort of general category of I don't have a whole lot of regard for like body language analysis stuff. And I know Rob probably disagrees with me on that one, but sorry, Rob.
I find it, it's entertainment. I think that it can be interesting. You just have to obviously take everything with a grain of salt. But I find it fascinating because we obviously are doing that all the time. We are communicating non-verbally all the time, and we're picking up on all of these things on a subconscious level, and so trying to be able to express that in a way that you can understand it consciously, I think is interesting. Like you, I'm skeptical, but I think it's occasionally fun.
The problem that we run into is when they start sort of offering like special insight, and when you get people who are like, oh, that's, that indicates lying. It's like, you actually take these guys and you put them through tests, and it comes down to a coin toss.
Yeah.
So that's why I get, that's where I get sort of skeptical, is you've got these people there sort of doing the special insight thing. And so I guess we'll roll the clip here just because it's funny.
Quackers, body behavioral analysis. Today we're going to be breaking down
the voice.
But look at him. Oh, I can't stand the way he sits. Oh, look at him. The way he just scoots on in. Looking at those two powerful women. He's gaslighting both of them. Look, and the little knob on the side of his jaw, it's going to stick out. That's what happens when you're an incel. Yeah, he's an incel, and you can tell by his bushy eyebrows, of course, and just the way he's looking at those two powerful women. Look at him back there, just flanked in between those two women.
Yeah.
He's gaslighting them. Oh man, so yeah, this is
him.
This is very much a send up, and there's a few tells. I don't know if you're aware that one of the more notorious of the commentators is a former FBI agent.
Oh, her. What was her username again?
Coffin Daffer.
Oh,
and so she's the one that, for example, got the whole hate grift going against Ann Taylor, has put out a whole bunch of frankly dishonest commentary about that. Things like saying Ann Taylor got a big raise for taking on the case, which she did not. There's a contract between Latah and Kootenai counties for her services to be provided, and Coffindoffer is acting like that's going directly into Ann Taylor's pocket, which it is obviously not. And so just a lot of that type of stuff, that's happening in the background of all of this. So yeah,
she's got to watch out, because some of the comments I've seen, I've thought have actually been actionable. Some of the comments that have been being made there, and I'm like, ooh, you got to watch out, because she's not going to start, like Ann Taylor wouldn't be starting anything with like during the course of this trial. But she's got 2 years to bring a claim?
Probably, yeah.
So we could see this trial end and immediately a defamation trial start, and that would be fun.
Yeah, I mean, I wouldn't blame her. Like you, I've definitely seen some things that I think would justify it. And then there was the whole thing with the Kara Kernodle, that was between Coffin Duffer and Ashley Banfield over there on News Nation, who I will not support. I'm sorry for the commentators on that channel that seem good and responsible and whatever, but you're tainted by your associations. I'm sorry, I just can't go along with any of that. So. Yeah, the whole thing with Kara Kernodle, the mother of one of the victims, Xana Kernodle, she's, battled drug problems her whole life. She was her daughter was murdered, and so she basically relapsed and was on warrant status, on the run, and they somehow finagled this interview to get her on camera to say, about her relationship with Ann Taylor and how, disappointed and betrayed she had felt because her lawyer is now, appointed to represent the family, or, the guy who killed her daughter. Well, it turns out that it's all fabricated. Ann Taylor's never even met her. We had actually known this. One of the, there's a Sleuthy Goosey is a Twitter account who does a fantastic research. Like she does it really well. So she had acquired some of the client files of Kara Kernodle from the courthouse, and was able to go through and look at the hearing minutes for all of these hearings, and never once has Ann Taylor appeared for her. So we had already known this, before it came out through this memo that got filed in the Koberger court file, kind of documenting this meeting that happened in court where they had gone over this issue of the conflict. And Ann Taylor had made it clear, I've never even met this woman, never given her advice. I just took over her case after she had already, she's on probation, but she frankly has a series of, chronic probation violations. So she kept, getting called into court. So I guess they just kind of kept an attorney on it. And it ended up being her at one point. So that was the extent of her relationship with Kara Kernodle. But News Nation used that to spin up this entire grift, this whole narrative of there's a conflict of interest that's going to damage the trial, and it's going to be an issue on appeal, and his conviction's going to get overturned. And they actually started a petition, like a change.org petition or something like that, to try to get her removed from the case. So really just a whole bunch of nonsense, way out of their lane on that.
Oh, and that's so, I mean, when you look at like public defenders, they end up having very tangential connections to tons of files.
Exactly.
It's
Exactly. And she is the lead public defender, the chief of the office for the largest county in northern Idaho. Like her name has been on a lot of cases just by virtue of her position. It does not mean that she's got a relationship with all of these people or that she'd have a disqualifying, conflict of interest in that situation, frankly, anyway.
Yeah, it's I didn't see that one when it was sort of a big deal, but like I was just like, this makes no sense to me as a conflict of interest. It's pure.
There was really no conflict. It was the one silver lining I'll put on that whole scenario is that it finally got me together with Natalie, with Nat Lawyer Chick. So we streamed together on that. Of course, we both have the public defense background. We're going, what the actual hell is this craziness? So anyway, go to her channel if you want to see our take on that whole situation. It's a while back now, but yeah.
And go to her channel anyway, because she's got great yeah, and people noting she's one of the few people qualified on death penalty cases. So yep, that really
exactly.
I mean, the other thing is public defenders stuff. You end up with like these sort of trivial conflicts that the court will ignore because they're trivial conflicts. Like quite literally, it can be like, oh, somebody got murdered and you did a bail hearing for them once because they were trotted out the door and you're there sort of doing docket court. And it's like, okay, sure. But that doesn't mean you have a conflict unless there's actually some meaningful tie.
Yeah. There has to be a significant relationship between the representations. It can't just be you're disqualified from, anything adverse to them at any point in time. Like, no, it relates to what type of confidential information you would have acquired by virtue of that representation. You don't assume, that the public defender learned your entire life story and everything else that you planned. I mean, no, I'm sorry. We're kind of busy. We're really just focused on this one crime, that you're in here for. And so something comes up on a different case that's unrelated. Yeah, there's no conflict. I mean, we dealt with this all the time. When I was working in Walla Walla County, 25, 30,000 people, a little bit bigger than Moscow, but somewhat comparable. And because your community of criminals, tends to be quite small and a lot of, repeat people and everybody knows everybody. It's kind of its own, I call it it's the criminal underclass. I mean, they've done it that way, kind of on purpose, but that's basically what it is. And so, yes, you're going to be running into the same people and the same names a lot.
And especially because the criminals tend to interact with and commit crimes against other criminals a lot. So you might represent somebody for dealing drugs one day, and then the next day your next client is like the guy who robbed him. It's like, yep, okay, like this happens. So yeah, unless you want the defense pool to be like this huge pool of people, there's going to be some overlap on these tangential connections. Especially when I was doing duty counsel work, which I've done a ton of, you might have 50 people come through the courtroom that day, and a lot of them just need an adjournment or something. And later on, if somebody said, hey, you represented that guy for an adjournment, I'd be like, what now?
Yeah. Who?
When?
Yeah.
So
yeah. No, and the whole thing too, that, I mean, it's a situation of somebody being so far out of their lane, and refusing to, quite frankly, defer to the expertise of those of us who this is squarely in our lane. I mean, I've taken these issues up in the Court of Appeals with conflicts of interest quite frequently. So I'm very familiar with the Sixth Amendment standard. And in that context, the bottom line is basically if Brian Koberger wasn't raising it as an issue, it's not going to be an issue. Okay. And he was fine with her. He's been fine with her from day one. To the extent I give credence to body language, my own interpretation from being in the courtroom and watching the interactions is that they get along great. They have a good working relationship. And, you know, I mean, she's obviously a very qualified attorney. It appears to me that he trusts her and he's following her lead, you know, taking her advice. What else could a lawyer want, you know?
Oh, I mean, that's way ahead of your average, you know, your average file right there.
Listen and do what you say is a dream client.
Yeah, it's, I mean, most clients can't even manage one of those things, let alone both.
Yeah.
Have you also followed the Chat GPT Mara Viavianka at all?
No, tell me about it.
Oh, so really briefly, because we went over this one with the chat previously, but
was this the guy? This is the lawyer that filed it in the court and they had the sanctions hearing last week. Is it that one? Yes. Yes, that's going.
Yeah, he files a case that he does with Chat GPT and
and
well, it's not
ChatGPT made up the cases. Like this is like an eye opener, I think, for a lot of people that ChatGPT will lie to you people. It's deceptive. It will make shit up. Like you can't trust it.
But it's so much worse than that because the opposing counsel said like, we got this filing and none of the citations appear to be real.
Mm-hmm.
So, and the court was like, you are directed to bring these citations to court. And so they asked ChatGPT to generate the citations. They didn't check them at all.
Oh, no.
And then they put them in an affidavit.
Oh, no.
So wow. I'm like, I mean, my thought was basically if they'd just done the ChatGPT law thing, what the court probably would have said is, okay, listen, you're going to pay some costs for the wasted time.
Yeah.
We're going to give you another 30 days. Please do a real filing and learn your lesson, right?
Yeah.
If they'd taken that moment to like check themselves and realize that this was a bad scene, they would have been fine.
Mm-hmm.
But instead, they doubled down with that affidavit, and that's where they get into a world of trouble.
Yeah, now you have ethics problems and you have a very justifiable, you know, complaint to the bar. I mean, that's not good.
Oh, and it gets worse because what I've got is the sadly they didn't live stream any of this, but thankfully Inner City Press did a live tweet of the live tweet thread of this, and it's bad. It's so bad. Some of the moments in it are real bad. So they put LaDuca under oath. How long have you been admitted to this court? Since 1989, which is a long time.
Yes. Long enough to know better.
Court asks him, how do you do legal research, you personally? And he says, I try to find cases I can use.
Oh, wow.
And the court has to be like, so how do you do that? And then they say that he used Fastcase, which got typoed there. And he does it online because he doesn't use the law libraries. I can't blame him for that. But what was your understanding of your obligation in connection with your March 1 submission under Rule 11? That's his affidavit, I believe. To be factual and truthful, I relied on my colleague Stephen Schwartz. Stephen Schwartz files an affidavit to try to get LaDuca out of trouble.
Okay.
And the court's response to receiving that affidavit, where Stephen Schwartz says, I was the actual author of this. LaDuca files it. And the reason why is because he's entitled to practice in federal court and I'm not. And so when the court got removed to federal court, I'm really the lawyer, but he's doing the filing. So
not helpful. It's not going to help him. Not going to help him.
So the court's response was to say, neat. I still need to hear from Mr. LaDuca on this, but I also now need to hear from Mr. Schwartz and the firm. You guys are also now brought in.
Wow.
So, court, did you do anything other than sign your affirmation? Did you read any of the cases? No. Did you do anything to make sure those cases existed? No. Then Avianca replied, I did not read it.
He didn't read the reply. Oh. Oh man.
Did Mr. Schwartz alert you to this from Avianca's reply memo? No. And when you got my orders of April 11th and 12th, I told Mr. Schwartz the court would like to see the cases cited. Do you recall writing to me you were going on vacation and the court giving you until April 25th? Yes. Was it true you were going on vacation? No, Judge. Oh.
Okay, so not only the big lies, we even have the small lies.
Yeah.
So is anything in your affidavit true?
And I like this. You did not see that this was a bogus case? No. You see that it's in different fonts? Like, oh man. The court is just like, this is ridiculous. So there's an error with the date. Take a look at this notarization. It's dated April, but notarized in January. When did you sign it? In April. That one I don't think is such a big deal, except for the fact that everything else was going on.
Yeah.
Did you have a vacation in April? No, but Mr. Schwartz was away. If I was the court, I would have freaking come over the bench at him at this point.
Yeah.
You put down that you were on vacation to cover that you needed more time because the lawyer you secretly had running the file in the background was away. What is it? Do you agree the 6 cases are non-existent? Regretfully, yes. I have all the answers I need. Do you want to make a statement? This pains me.
I bet. I bet you haven't started to hurt yet.
Yeah,
I bet there is a lot of pain you have yet to experience.
Yeah. Yeah. I should have been more skeptical. I worked with him for 27 years. This will never happen again. The court might guarantee it never happens again. Although I don't think they're gonna disbar them. I think suspension is likely, though. I think suspension is merited here.
Yes, I think so too.
Schwartz.
I mean, you can't get depantsed like this. Being this dishonest to the court is just not gonna fly.
If the guy had just filed a bad document, because of the ChatGPT thing, I would have said, like, everybody learn from this and move on. But the false affidavits, including the, like, you wrote to me and said you were going on vacation.
Yeah.
Oh,
it's
on you.
It's never the crime. It's always the cover up. If they had just fessed up and said, yes, our bad. Sorry, we made a mistake. I don't know what it is with so many lawyers that are like petrified to admit that they've made a mistake. We've all made mistakes. Okay.
Yep.
It happens. And frankly, what you need to do is throw yourself under the bus. Acknowledge that you made your damn mistake. Suck it up. Take your lumps. That's what a professional does. To try to create this charade, to avoid having to do that. That's what is, that's what gets them in trouble.
Well, I had a situation. So my printer ran out of ink, and this is the dumbest mistake ever. So I went and filed an important court document, and I didn't check it. I printed it out. I ran to the courthouse because I was doing it at the last minute, and I filed it before the deadline. And then I get a call from the other side because I also got it served on the other side. And they're like, did you mean to file a document that cuts out mid-sentence and then has like 8 extra blank pages?
Oh, geez.
No, I did not.
No.
Are you okay with getting the proper document the next day? And most Crown prosecutors would have been like, yeah, I get what happened here. Not a big deal. This guy was being a jerk. So what he did was he was like, I'm opposed to you filing late. So I had to go into court and be like, I need to file this late, please. Can I file the right copy? And the judge is just like, whose mistake is this? And I'm like, it's mine. And they're like, well, did your assistant help you? I'm like, that's not relevant. It's my name on this, so it's my mistake. I don't. And the court's like, all right, then I think my work here is done. You understand the problem. I'm going to allow the late filing. Crown, do you need an adjournment of the trial date, or are we good to go? The Crown's like, I guess we can go on the trial date. It's like, cool. Everybody's happy. But the court was just like, hey, did you actually, like, are you going to take responsibility for your mistake? I'm like, yep, you bet I am.
Yeah. The throw the assistant under the bus is always that's a cheap one. I've seen that one a few times. That never goes over well.
Yeah. And I mean, if your assistant does bad work, that's on you.
Exactly.
Because you have a duty to supervise your assistant.
Exactly.
Yeah. And anybody who throws their assistant under the bus is kind of cowardly.
Yeah.
I mean, and your assistant might have screwed up, but it's still your fault.
It's still your fault. You need to check it. Like you said, you're the one signing it. Did you sign it or did you not sign it? You know?
Yeah. Is this not your name? Your assistant, are they a lawyer? No? Okay. Then a lawyer has to be responsible for this, right?
Mm-hmm.
That's you? Cool. They get asked, the next guy gets asked, Schwartz, how do you conduct legal research? I research cases. It's like, oh no.
Do you read them? Oh, this judge has had it.
This judge is so pissed. So pissed. Now this one is interesting because did you prepare the March 1 memo? Yes, I used fast case, but it did not have federal cases that I needed to find. I tried Google. I'd heard of ChatGPT. Now, the background on why it didn't have federal cases is that it's screwed up. Like there was a billing screw up, which I think is probably just I don't know who to attribute that to, because I've had situations where like my Westlaw subscription, they're like, this is not in plan. I'm like, but it should be. So why is that not in plan? But then instead of like getting that corrected and adding the federal cases that he needs, they just go to ChatGPT. And then, so, all right, what did it produce for you? I asked it questions about the Montreal Convention or the position you wanted to take. Yes, for our position. You were not asked for an objective view, but cases to support your position. I asked it for its analysis. He actually asked it to, like, if you read the
prompt.
The prompt
is like brief this position.
Yeah, it was like provide cases to support that the limitation period was told by the bankruptcy.
Yeah.
So he's weaseling here.
Yeah.
So I thought ChatGPT was a search engine. Do you cite cases without reading them? No.
Except for this time, obviously.
Did you look for the Varghese case? Yes, I couldn't find it. And yet you cited it in your filing. When you are getting cross-examined like this by the court,
yes,
a lot of lawyers forget that judges were lawyers.
Mm-hmm.
It's real easy to do. And they were probably lawyers for like years and years and still remember how cross-examination works. And if you make them break that out on you, you are in a you're having a very bad day.
Yeah.
Was it Mr. Schwartz? I think you were selling yourself short. You said you verified courses.
Oh my God. He says, I'm operating under a misperception. And the judge says, you're selling yourself short. That is on the nose.
Yeah.
Wow.
Yeah, the judge is getting snarky. The judge is getting sarcastic.
Mm-hmm.
And we've got Rob.
What's up, Rob?
Hey guys, how you doing?
Oh, we're having a Monday. It's not the worst Monday, but
I'm having a better Monday than this lawyer.
Yeah,
everybody's having a better Monday than this lawyer.
Oh yeah.
This lawyer is enjoying one of his last Mondays as a lawyer.
Well,
I mean, if I was this lawyer, I would not have attended for this cross-examination. I would have been like, please find that you do not need to conduct this on the basis that I've already turned in my law license and have,
Right.
like, moved into the forest to live as a bear. Like, you know, you will never see or hear
Live
from
as
me
a
again.
bear?
I am just going
Did
to
you say
vanish.
live as a bear?
Yes.
Where do you get these statements? Like, is there a book that you're referencing, like, randomly?
No, it's just like, you know, that would be a better choice than what they're doing here.
Probably true.
So, like, would you not just want to avoid all of this? Because how do you justify any of this at all?
You can't.
No, you can't.
Because when
You
you
say-
sign a piece of paper as an attorney, that's your statement that you have researched the law. And what he said was, I look for cases. No.
Yeah, that was just so bad. So bad. Yeah, I thought there were cases that could not be found on Google. Yeah, you've got a responsibility to make sure it actually exists before, like, any of that. So,
I mean, before citing them in a pleading that says, please don't hold me in contempt.
yep. Which, I mean, that should be your clue, right? This is like a sign that says, hey, there are landmines in the area, and you keep dancing.
Maybe like the position you had of ChatGPT, like said, trust me, bro, you might want to reassess that. Just saying.
Yeah. 6 cases, none found on Google. This non-existent case, Varghese, the excerpt you had was inconsistent, even on the front page. Can we agree that it's legal gibberish? I see that now. I thought it was excerpts. How can you, like, when you read it, it just makes no sense. It actually has 2 different, like, directions that it goes. And then, yeah, when Avianca said you cited non-existent cases, they said they couldn't find them. I figured I'd go back, but I continued to be duped by ChatGPT. I wanted to be transparent to the court. I went to ChatGPT. Judge, we're not up to that.
This is literally like those darn kids and their meddling. They caught me as I had my mask, like taking off my what?
Yeah.
And Avianca, put your cases in quotations. Like, they were dunking on you, sir. Did you not notice you were being dunked on? You know what F3D means, right? A federal district, 3rd department.
Oh, God.
No. Is that really what he said?
That's really what he said.
Really what he said.
Oh, that is so bad.
I wonder, was that sincere? Was he just like snarking back at the judge
There's
now, or does he
no
actually not
way.
know?
This does not seem like he was in a snarking kind of framework, and this was not the time to get brazen with the judge.
Like,
I know.
Mr. Runkle, there are times when you can engage in your level of snark, but now is not that time.
Yeah.
I mean, I could forgive, sometimes a good defense is a good offense, right? I don't know that that's correct in this occasion, but I could understand, the maybe mis-strategizing on that.
But he hasn't been doing that in this, right? That hasn't been his approach. So, yeah.
That's a book, right?
Yeah. Have you heard of the Federal Reporter?
Whoa.
Right?
Oh, God.
Hang on, I have to look at...
Have you heard of the Federal Reporter? Yes. That's a book, right? Correct, says the judge.
I had pity for these guys.
Nope.
Like, I really did. I wanted to think, like, benefit of the doubt. They just screwed up. They're going to throw themselves in the mercy of the court. They'll be fine.
No.
This is not it.
No, that's what I said, Rob. Like, had they done that, it's no problem. Like, okay, you're a little bit embarrassed and whatever. Yep. And like Ian said, you probably get some sanctions for costs or whatever for wasting people's time. But it's the cover up. It's not the crime. It's the cover up. And they dug in and doubled down, and really, busted their flush on the river.
The sad part about this is this basically suggests like years of how long did the guy say he was a lawyer for?
Since
Like 30
'89.
years.
Yeah.
Yeah.
This like suggests years of, I hate to say the word malpractice, but
Mm-hmm.
Mm-hmm. Well, and then so how could you say you thought they were unpublished when they're in a book, right?
Yeah.
That's what the citation says. Oh, and then so you were the one going on vacation, returning April 18th, because his co-counsel told the court that he was going on vacation, not because he was going on vacation, but because Schwartz, the guy who was secretly writing stuff, was the guy going on vacation. And so, yeah, the lying to the court is really going to sell well.
I think the judge walked into this hearing going, I do not want to sanction these attorneys. Please give me any reason not to do this.
I think the judge is going through this whole thing hoping for them to like realize that they screwed up and to beg for to just say, we screwed up. We're begging the court's mercy on this one.
Yes.
But they never get there. Judge Castell, when you saw the court's order, it wanted to see the cases. Did it cross your mind that the court checked for the cases? This is the kind of thing that I just do not ever want the court to be like. This is how I never want to be treated by the court.
Ever.
You told me that ChatGPT supplemented your research, but what was it supplementing? I'd use Fastcase at the beginning. ChatGPT wasn't supplementing your research. It was your research, right? Yes. Again, we see the cross-examination full flow here.
It gets worse.
Yeah.
Oh God! And then even the affidavit. The
affidavit you prepared with the different fonts. How was it notarized? We used an older affidavit and just changed the caption and the content. We forgot to change the month. But you corrected plus H to plus TH and the year.
So they corrected the days and the years. Oh my Lord!
They just missed the January versus April.
Oh man.
You prepared the affidavit and then what? I probably went into his office. Where is that? 20 feet away from mine. He looked over it and he signed it. Anything else? I apologize. And then I apologize was a great start. I love that start.
It's a start.
And then he drives that good start directly off a cliff into a lake, which is also on fire.
Yeah, because guess who's the real victim here?
I have suffered professionally from the publicity this has received. I've never been involved in anything like this. I hope I can put this matter behind me. I've taken a CLE court on artificial intelligence. Safeguards will be put in place.
That's a whole lot of me.
I've never been caught red-handed like this before, Your Honor.
And judge, here's the thing. What this is, if I had walked into this hearing, Andrew, you can probably say the same damn thing. I imagine you probably will. If I had walked into this hearing knowing that I had cited law that did not exist, I would be mortified because not just what I did. Yes, that would make me terrified. But if the judge had accepted the law that I had given him or her as an officer of the court and made a decision based on that law, I would be absolutely mortified, and I would do everything in my power to fix that. This is about candor to the court and the inequities that can happen as a result of attorneys just disregarding that.
I don't even like when people mischaracterize the cases. Okay, people can twist existing case law around in ways that offends my sense of candor to the tribunal. Let alone just making something up out of thin air. It's unbelievable.
It's terrible. This, Judge Castell, does the law firm representative have anything to say? We regret what's occurred. No kidding. We practice primarily in state court. Fast case has been enough. There was a billing error and we did not have federal access. Avianca's counsel says this case should be dismissed. They have no case law. I mean, I don't know that the case should be dismissed because that mostly just harms the client.
Yeah.
I think that they
But
should.
the client did choose these lawyers.
That's true, but the client probably thought that they were going to lawyer.
You would hope.
And, I mean, I'd yeet the lawyers and tell the client, like, hey, you're going to have to get some new counsel on this. And new counsel is going to have to determine if the argument that they want to make is viable. Yeah. Counsel to Schwartz says this has buzz due to Schadenfreude, and because it's hilarious.
Yeah.
They say the cases seemed real. There were no disclaimers. Seemed real is not good enough. You've got to actually check, right?
Also, there were no disclaimers. If you're an attorney, not a good way to get business.
No.
Yeah. I'm too stupid to check for myself. Yeah, I mean, these guys, if this is a good reason to like put your lawyer's name into Google, because if this is what pops up for your lawyer, you might want to think about some things. And he says, I'll be taking this under advisement and entering a written decision. If I was them, I would be losing my mind right now because the written decision is still waiting, like still pending.
Yeah. It's gonna be a nuke.
It's gonna be a nuke.
That's the thing. Like, there was a way to go. There was a way to do this. There's a way to do this. Like look, I was a young lawyer once. My first case, I was in court within a week of essentially being hired as an attorney. It was a first return on an assault charge. And the judge asks me, because I didn't realize, because the attorney I worked for no longer works as an attorney, but I didn't realize what a rule on witnesses was. They don't teach you that stuff in law school. You learn that in practice. So the judge asks, Mr. Morton, would you like a rule? And I said, a rule. And the judge says, Mr. Morton, would you like a rule that excludes witnesses from the courtroom so they don't hear each other speaking? And I said, Judge, yes, that. I want, please, thank you, that. But there's the humility of kind of recognizing where you are.
Mm-hmm.
Show up, recognize you made a mistake. The judge is going to give you slack because we all make mistakes. The judge has made mistakes. Mm-hmm. This is the wrong message to take. But ChatGPT is a great asset. I definitely didn't. They didn't have disclaimers. Come on.
Yeah. The poor me approach, I think, is what really sunk the ship. You know, if they had managed to even with the defensive approach that they had taken, I really feel like if they had just managed to not go down that poor me road, maybe it wouldn't be quite so bad. But trying to make yourself into the victim, the person who deserves the sympathy in this scenario, just a terrible strategy.
What I probably would have, I think the approach I probably would have done was to say, we've made a terrible mistake. We did not realize just how inaccurate this was. And worse, we should have been alive to it when the court raised it. We continued to make the mistakes. It was not an intentional misleading of the court. We just screwed up. We screwed up. We accept whatever punishment the court is going to lay down. We ask that this not rest at the feet of our clients. This is our mistake.
Yep.
Please, whatever you're doing to us, please don't hang it on the clients. And, and we acknowledge our error. We will, we've taken steps to do better, but, this is a real bad screw up, and there isn't an excuse for it. And I think the court would be a lot more forgiving of that than, but yeah, no, they blame everybody but themselves. And, it's like the worst approach that you could possibly take on something like this.
Also, kudos to Inner City Press. He is everywhere in New York, man. He is everywhere in these hearings.
Well, and the other thing is that's some great live tweeting, because I'm
Yeah.
sure that he's only capturing part of what's going on, but he's capturing the essential bits there.
Question,
And,
answer. Question, answer.
Yeah.
Not like I felt that they were doing this or like, no, question, answer.
Yep. No, it's that was great. It's useful. So I was super impressed by that live tweeting there. So
Definitely. There's a real skill to that. As I discovered in the Coburger courtroom that I would not be doing the live tweeting. Have not
Oh,
developed that skill. Please
can
follow
you-
the others.
Can you tell us what that courtroom is like? I don't know that I'm a fan of this judge right now.
Oh, really? Oh, okay. I love the judge. I love the judge more and more every hearing. I'm such a judge fan. That's just my perspective.
I don't know you well enough to know
can't
if that's
get over his name.
sarcastic.
No, that's his
No.
name.
Yeah, his name is Judge.
No,
John C.
I knew it was
Judge.
Judge. I knew it was Judge C. Judge, but
Yeah.
because well, I will say that when we were watching, Ian, how long were you on FNF when we were watching the gag order stuff?
A little bit. I was having to juggle a bunch of other stuff. So
Shannon Gray killed me. He had an argument.
Shannon Gray's the worst.
oh yeah.
He had an argument. He had a damn good argument. He had an argument to make. He started down a decent path of making that argument,
Mhm.
and then the wheels came off, and
Mhm.
they
And
stayed.
caught fire and
Yep,
yeah.
all
Yeah.
the things. It was like,
Yeah.
and then when the judge tried to get him back on the argument, he was like in no
He
man's
was
land.
snippy
Like,
and
like
Yeah,
where,
defensive.
where am
Like
I?
defensive. Yeah.
About him, not about the right things. There's a
Yeah.
way to make that argument, damn it, and the judge left
Yeah.
it open. Urgh.
Yeah. No, I the thing that really stands out about that courtroom to me is, the players all know each other. That to me is very obvious. This is clearly, said it a million times, small community. It's a small legal community in northern Idaho. The AP lawyer, knows the defense lawyer, and I mean, there's all these connections and stuff. So they all know who each other is. They know what their approach is. They know what their style is. I don't think that any of them were particularly, surprised by how things unfolded in that courtroom.
Well, Andrea, at some point I saw that like on Twitter, I don't know if you tweeted or someone else tweeted it, but there was an issue with you getting asked to leave the courtroom.
Oh, this was at the arraignment. So yeah, this was when me and my friend Heidi went to the arraignment, and we were the last people to make it into the main courtroom. So we're sitting at the very, very back, and there had been this woman who was kind of coordinating all of the press and like the line and stuff. So like you showed up, and she asked for your name, put you on the list, and asked who you were with. So she's keeping track of like, okay, this is NBC, this is ABC, this is News Nation, like whatever. As it turned out, those were apparently like being used as place savers because there were only like 10 actual people ahead of us in line. But yet by the time we ended up going into the courtroom, like, 5-6 people per outlet or whatever, we're ending up right here at the very back. So I'm kind of scratching my head about that. But anyway, so then this lady comes in, and she asked me and Heidi if we would be willing to leave and go over into the overflow courtroom because there's this media person, who wants to be in there, and couldn't. And she's like, it's media. I'm like, this entire fucking room is full of media. Like, come on. I'm sorry. What is one more media? Boot out an ABC if you want to make room for the Lewiston Tribune.
There isn't room in that courtroom for anyone but media. That's the issue I have with it.
Well, yeah. and the media has been getting, from my perspective, quite preferential treatment. They still, on this hearing, for the gag order, they had labeled, the benches. And so these ones are set aside for prosecuting. These ones are reserved. These ones are media, and so I understand, for example, like the front row where they have the cameras set up. Yes. Okay. You need room for your camera people, your production people. I don't particularly have a problem with that. But otherwise, the media is not a freaking special class. Like they don't get special treatment. They're no better than any other member of the public. So I don't particularly care for that. I went with an extremely talented artist, okay? And our number one priority was getting her the perspective that she needed to be able to draw some absolutely killer freaking live courtroom sketches. Okay? So
Which
that's
were awesome. I
Those
do
were
want to say
amazing.
those were awesome.
she's amazing. She's like one of the most talented people I've ever met. So yeah, she absolutely did an amazing job, but we're going to have to probably fight for that. Like every single time we're going to have to like always be early, always, you know, be kind of throwing elbows a little bit with the media so that, you know, we can stand on equal footing with our superiors in the press.
This is why I love Judge A, who was just like, okay, media, you are entitled to access.
Yeah.
Yep.
That's
Because
it.
you're members of the
Here's
public.
the pool feed. Yeah, here's
Yeah.
the
Yeah.
pool feed.
Here's the
And-
pool feed. You get access via that. And if you want to be there in person, so does everyone else. Get in line. You are members
Yeah.
of the public. There's the line. It was actually hilarious just how many like random reporters would show up at like 7:30 for an 8 o'clock open and be like, hey, we're media. The
Where's my media
deputies are
pass?
like,
Yeah.
deputies are like, line starts back there and you're not getting in today.
Yeah.
And they're like, well, don't I get a media pass? Nope.
No.
No, you don't.
No.
So then they do a story about the line. There were so many stories about the line because they couldn't wait, wait for it.
Well, and that's a good question for Andrea. Like, what is it like there, like outside the courtroom when these hearings are happening? Is there a big public presence? Like, are people looking to get in?
So for the arraignment, there were a couple of people that we met in line that were rando public people like us. There was a couple from Spokane that we met, a couple that came up from Lewiston that we met. But by and large, it's almost entirely media. This particular hearing, there were a couple of law students that I guess were like interning at the Kootenai County Public Defender's Office. And then there was me and Heidi, and there was a bunch of press, and that was it.
I figure there's
Wow.
less people who want to see the people involved on this one. Because like with Depp, people wanted to see Johnny Depp and they wanted to see Amber Heard. And meanwhile, I wanted to see the jurors.
And
Yeah.
So
Yeah.
I caught your guys' comment on the body language stuff, and I have seen, and I agree with Andrea a lot on this one. Body language to say whether someone did or did not do a thing. Bullshit.
Mhm.
Body language to say that whether someone is evading a question and I should probe that question, or they're uncomfortable with this line of questioning and I should go in that direction, that is valuable. What I saw the judge pointing to were a bunch of people on YouTube, and they're there on YouTube, on mainstream media, who are looking at Brian Kohberger and saying, during this hearing, they were trying to analyze his body language. What the hell are you doing? He's not saying anything. There's no questions being asked of him. There's nothing there to give you anything whatsoever. There is nothing you can glean from that. I don't give a crap who you pretend to be. That is junk. That is crap.
Yeah. And there's no normal for a guy's, first appearance in the courtroom, in a scenario like this. Like what is supposed to be normal? Like it's just going to be what it is. Okay, maybe 20 hearings down the road, we might be able to, discern some patterns and stuff and draw some inferences from it. But this whole just, he's looking around in a certain way, or, the expressions he has with his lawyer. I mean, it's just not particularly helpful, I think.
Well, and I mean, it's long been sort of noted, at least in Canadian courts, that demeanor evidence is some of the least useful evidence that is, that you might have, like how the person looks on the stand. And in part because that was responsible for a lot of wrongful convictions. Canada's got like a large group of diverse Indigenous populations, and they have very differing cultural norms, sometimes that go back thousands of years, And so one of the things that happened is they started bringing up, white judges to like Northwest Territories, and they were saying this guy looks guilty because he won't meet me, like he won't meet my my eyes.
Mhm.
Well,
That's being polite. That's being polite, probably.
in Inuit culture, that's a sign of respect, right?
Yeah.
Is that you don't meet somebody's eyes if you're treating them with respect. That's sort of seen as more of a confrontational gesture, or so these guys are being determined to be liars when they're getting up and testifying in their own defense, because really what they're what they're doing is they're just being respectful to the court.
Yeah.
So that gets to be an issue. But I mean, we all have to do some judgment, because sometimes you see a witness and you're just like, oh, that's clearly BS.
Mhm.
But where I get into a problem is where they get into this sort of like special knowledge thing. Like,
Yeah.
oh, I've got this special cue that indicates lying. It doesn't, though.
We didn't need an expert to tell us that when you're like fake sob heaving on the stand with not a tear on your face while you recount, your horrible abusive marriage, that you're absolutely full of it. You don't need an expert for that. It's the kind of thing that people can just intuitively understand.
Yeah.
That's why we have juries. That's why we have juries.
Also, random aside, Rob, when did you start a law firm up in my area? This is literally a law firm. Oh, it's
Wow.
cycles. But yeah, they've got billboards with this image. It's kind of creepy.
Just a little.
Yeah, I was like, what the heck? That said, it's not nearly as creepy as this image. Have you heard of the guy who filed his LSAT score in a court filing?
What's his name? Moody or something?
Mark J. Blunt.
Blunt, yes.
This guy is my hero. Not my hero. Like, he's definitely not my hero. But the hilarity is awesome.
I'm having fun taunting him because he's bragging about his LSAT score and I did better than him.
Yeah.
Of course, it doesn't matter for anything, but it's still fun to be, because he thinks it's super important.
Yeah.
But he just posted this picture of himself going, just got sworn into the State Bar of Tennessee. And this is the picture he's posting.
That is really uncomfortable.
That's really uncomfortable and creepy and off-putting. And I'm like,
I am also tense watching this photo. I feel very tense.
You see, like, he's got one eye.
Deliberately drop my shoulders.
He's got one eye pinched like way tighter than the other. That smile is just kind of like, this is the guy who, if you see him coming in an alleyway, you turn and run the other direction. Like, if I took a picture like this of myself, I would delete it and
yes, rapidly.
like, not post it for everyone to see, because this one is just like, ooh, yeah. But well,
guys, I hate to have to dip on you, but I have to dip on you. So my dog got spayed today, and so she is in her recovery mode, and she badly needs my love and attention. So I'm gonna go give her some snuggles.
Poor pup. Give the pup some extra snuggles on our behalf. But if you haven't read that filing, you should read that filing. It's exceptional.
Yes,
he cites Dred Scott.
Oh, fantastic! That's always always a winner.
No.
And he cites it for exactly the proposition you're hoping he's not citing it for.
Oh no! Oh yikes!
Hi, Andrea.
Well, I'll check it out, guys. Thanks for having me.
You haven't seen him forever.
I know. We'll do it again.
Absolutely.
You guys.
Cheers. All right. Yeah, you haven't read that one?
No. You're gonna pull it up, aren't you?
I could, but it's long. I'll give you a basic summary of his argument.
Crap.
Step one, I am a very smart lawyer. who got a 173 on the LSAT.
Bad.
Step 2, he argues that there is a special class of people in the U.S. who are descended from the original, like the people who were there at, the original 13 colonies or whatever.
No.
He files his family tree as an exhibit.
Nope. No, he doesn't. You're lying to me. You're not telling me.
No,
the truth.
he straight up does. And he argues a genetic right as a descendant of, this bloodline to own a machine gun. Oh, and he cites Dred Scott for the proposition that there are some Americans with more rights than other Americans. He doesn't specify which Americans he's talking about.
The answer is no.
Yeah.
The answer is actually kind of like a fuck no.
Yeah. He had a filing he had a service deadline. So I don't know if he's actually successfully served his documents on everybody that he needs to.
I don't care. I don't like him.
But I suspect the court's response is going to be, "Dear sir, please find enclosed a flaming bag of shit."
Yeah, there's no.
Yeah, it is exceptional.
I can't.
It is just absolutely exceptional.
Well, that's a thing I didn't need to know.
That's a thing. And I never actually ran the Spice Must Flow intro. We'll do that.
That's why I checked the.
There. Sorry, I didn't mean to cut you off.
No, that's why I had to look at the time.
Yeah. It is so I'm pretty sure it's the worst filing I've ever seen. And
but Ian, he got a really high score in his LSAT.
He did. It's still worse than here where I am. There was a filing where the court actually rejected the filing and said, "This is too bad. This is too terrible. We won't accept your filing. You have to do it again." And that filing is worse. So, yeah.
Congratulations, attorney. You got a filing that was, well, maybe not.
We need Kurt to do the Blackleaf voice on that.
We kind of do. That's a fantastic idea.
Congratulations.
Congratulations, young attorney. You just ended up in the Hall of Fame of filings that you never want to cite.
Oh, man. I mean, they still mention Dred Scott in U.S. law schools for the historical value and the
lesson to not mention Dred Scott.
Yeah, never, ever, ever, for any reason, should you cite this.
Correct.
So, yeah, it... yeah,
that's a thing, Ian. People are people.
People are people. What happened to Gimlet after I left?
Gimlet, well, being in his pumpkin form, we couldn't really take him a lot of places, so I think we have a quasi adventure
behind him.
We kind of left you behind, not totally behind, but kind of behind. We'll come back for you.
Oh, that's just wonderful.
I mean, I think we'll come back for you. Gimlet's been saying some nasty things to Ghostblade.
You slapped Ghostblade, or you slapped Gimlet rather. So you got no complaints.
He said a nasty thing to Ghostblade to get a slap in the back of the head.
That wasn't that nasty.
There's
Okay.
a whole section of the chat that's very confused right now.
There's a whole section going, what is this about? We're talking about Lawyers and Dragons, the D&D game we play every Saturday morning on Hoag's channel.
Which
So,
is like the most fun ever.
Oh, did you ever expect, like, because you'd never played before?
I never, ever, 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 ever saw that I would be having this much fun.
It's just a ton of fun.
Yeah.
It's David, the GM, is just fantastic. So
Yeah.
that's exceptional.
I'm gonna throw on safety glasses and switch the camera over so you can see.
Oh, awesome. And while you're doing that, I will bring up, I guess, one of the other things that's been going on. This is like unheard of. So, Supreme Court Justice Russell Brown has stepped down from the Supreme Court. That's Russ Brown. You might be thinking that this is Christmas that he's dressing up for. This is actually how the Supreme Court. This is how the Supreme Court justices dress for court. So, he's not doing a Santa outfit. But basically, what had happened is that he got accused of, or a complaint was made, basically saying that he was behaving in a creepy fashion. But the court investigated. They found that there wasn't anything to charge. But this guy, John Crump, a U.S. Marine veteran, punched him to get him to leave. And so then they reported him to the CJC. Brown had said that his version of events is false, and basically said that the Marine punched him in the head for no reason. What is it? Brown had said that the probe might continue into 2024. Delay, he said, is in nobody's interest, the court's, the public's, my family's, or my own. So he's therefore decided that the common good is best served by his retirement so that a replacement judge can join the court in time for its busy fall term. He had hoped that the review would be dispensed with quickly and would not impact the court's business, but that has not been the case. His lawyers also called it a regrettable result prompted by a spurious complaint. That's the Supreme Court building. I have been there once. This is sort of interesting. They had a report from the officer, the police officer, who had asked this guy, "You called police to say you beat up a guy?" That was it. And then the Marine, when he was told your hostile and aggressive demeanor has no part in this communication, it's not going to be productive at all. The Marine told the officer, or shut up, dude, just shut your mouth, Crump said to the officer before Balcom threatened to arrest him for disorderly conduct. So, ultimately, this is a sad situation. We don't know what what this ultimately would have determined, but I think it's kind of unfortunate that this is sort of how this went down. We're going to do that. I liked Justice Brown. I like Justice Brown. He is a good justice. I've liked his opinions. I've liked his reasoning on things. So I'm concerned about who's going to replace him, because that's going to be coming from the Liberal Party of Canada. And that looks like pen turning. That'll be a block of either pure epoxy or stabilized wood. That'll be interesting. You can see he's got the guard there, which is I approve of that. That's the guard is at the top there.
Isn't that angle kind of cool?
that is a very cool angle. I have lathe envy. I have CNC envy. I want all the things in your shop.
Well, I made that blank too.
Did you?
Oh yeah.
So
And
that's like
wait till we
that's-
see what it looks like. Because look at the
that's poured
colors.
epoxy then. Like just
Oh yeah, like I poured it with all the different resins. So we're gonna see what it looks like. So it should only take a few minutes to get this thing whittled down. But I'm gonna mute while I do. So you keep going.
Yeah, because otherwise we're gonna have it's gonna be nothing but lathe sounds. So that is, but I'm super curious because yeah. So for people who don't understand what a lathe is, it's basically it's a thing that spins an object, and the reason why it does that is that then you can use a chisel to sort of carve away because that thing is spinning so fast. You can then carve stuff off of it in order to make cylinders. Basically, it's great for any sort of cylindrical object. So pens, which are basically a cylinder, bowls, which are sort of radially symmetrical. All of those things are great on a lathe. But the downsides to lathes is that they are somewhat dangerous equipment. As you can see, they throw a lot of chips. The epoxy chips aren't so bad typically because you can see they're kind of light and flaky. Wood chips can sometimes be a little more dangerous. And he's got some stuff clogging his lathe there. I don't think it's going to be a problem, but it's still kind of entertaining. The other thing is that sometimes things can burst, but if you get something tangled in the lathe, it can be exceedingly dangerous. So if you've got, there we go. The toothbrush is the shop toothbrush is an excellent, option there. Just don't use that for teeth now. But if you end up using a lathe, and you get your hair caught in it, it will absolutely mess you up. A lathe is, it's not a gentle piece of equipment, and they have been known on occasion to kill people. So be very careful with the lathe. And Rob has assured us that he's got his safety glasses on, so we believe him. That is good stuff. Oh, hey, we've got Kurt in the chat. Runkle drools, Rob rules. Fair enough. Kurt, do you want an invite? I can toss you an invite if you're free there. I see Kyle Fox saying, at the local hackerspace, we treat lathes and milling machines like firearms. They can kill you very quickly. Lathes are one of those pieces of equipment that if you screw it up, you can end up getting killed faster than somebody can rush up to hit the kill switch on it. They can kill you faster than you can recognize what's going on. And this is the other thing: never wear gloves when you're using a lathe. They can rip your finger off if you're wearing gloves, because the glove can get caught, and so if you use gloves with it, you can get into a lot of trouble. All right, I am sending Kurt a link. There we go, on civil law. Coming your way. There we go. All right. Yeah. A lathe would be happy to wrap you around it like a noodle. Yep. Hey.
Hello.
How you doing?
Great. It's Monday night, which means I just came home from improv. I do Monday is my class day for improv.
Oh, awesome.
And so I just got done. We meet 7:00 till 9:30, and then we usually go out afterwards for a drink or two. And then I just came home 11:00. Had a great time as always.
That is fantastic. I actually suspect improv is probably really good if you get into court, like just doing any sort of oral argument or any of that. Because
sure.
Yeah.
I also, of course, use it for the YouTube as well, because as you're engaging with chat, right, they're basically essentially giving you nothing but premises, and then you can use it to improv and stuff off that. And as you and I are talking, obviously, we're building realities together. So I figure it's useful for my streaming talents. So That's one of the ways I try to become a better presenter for you.
You hear that, chat? He's working on his craft to be a better person for everyone here. That's admirable, because
Yes.
I just kind of muddle along.
Yeah. And we do all kinds of things. And I just figured out a new methodology for shorts. So I've been rolling those out. Those seem to have been successful recently. And then I've been using ChatGPT. I showed a little bit behind the scenes. I keep messing with the information or the way I ask the question, but I keep using it to help build titles for my edited videos and video descriptions, and come up with image generation prompts from Midjourney to moderate success. So
cool. That's
always
awesome.
trying to find a new tactic or a new tool to make things better. We're continuously improving over here on Uncivil Law.
The YouTube game is getting pretty tough these days. It's kind of I've had some subscribers shrink, and I think a lot of people have had the same, because it's just I don't know.
I've suffered a little bit. I've suffered a little bit of loss, but not as much as some other people. I was stuck at like 123 for a really long time. It took me forever to drop to 122, so I haven't suffered as much loss. I haven't had as much gain either. When I left my job, I think I had just passed 100,000. I have to double check, but it was close, because I just passed 100,000 before I left my job in July 2nd, and that's almost a year ago. So I've only gained like a fifth of my trafficking again. I lost a little bit initially. I forget which LawTube drama it was, but I lost like 5,000 over some drama. So I dropped to 95,000 for a while, and I had to build my way back up again. So now we're at 122. So fun times. Mistakes were made mostly by me.
Yeah, I mean, that happens. I hate the drama stuff, though, and I mean, it just is what it is. But
I've definitely made mistakes along the way, and I hopefully learn from to make less of them in the future.
Well, and one thing I think is really interesting that you're up to right now is covering the Scott Peterson trial.
Yeah, really interesting case. This is Parkland, Florida. School shooting occurred February 14th, 2018. 14 students died, 3 adults, 17 total deaths, 17 injured. The killer himself has already been tried. He pled guilty. He was sentenced to sentenced to life in prison, rather. It did not get the death penalty. So controversial.
That surprised me.
Yeah, so controversial in Florida passed a law to try to do non-unanimous death penalty verdicts in the future, which is probably unconstitutional, but it's another problem for another day. This guy was the school resource officer. He's a fully licensed, fully badged police officer. It's just that his duty station is the school, as opposed to, being a cop on the beat or walking a corner or being in a car or whatever, right? So for the last 9 years, his duty station was the school. He's been accused so much of cowardice, in so many words, negligence leading to another person's death. The thing is that the information is a little unclear at this point in the trial. He seems to have been alone while the shooting itself was underway. If I understand the factual picture, no other officer was there while the shooting occurred. He was there alone. This is relevant because the campus is 45 acres. It has 3,000 school students. It's a big
45 acres is a big,
It's a big campus. It's multiple football fields in length, and so it's a lot for one person. So it's unclear exactly what he was doing or what the information available to him is. So the state so far has been leading with a lot of emotionally heavy testimony. It's basically been a cycle of student, teacher, police officer, in varying degrees of, this is the horror show.
Right.
But not a lot about what the defendant actually did. They keep alluding. They keep asking, like on cross or on direct, like, would it be responsible to hide behind a car for like 40 minutes? But they haven't actually demonstrated that's what the defendant did yet. So I assume that's coming later. So a little unclear. Also, his legal liability is unclear. As I understand, they're trying to charge him under a statute that requires him to be a caretaker, which I'm not sure he is legally. The judge apparently is letting it go to the jury, but ripe for appeal. So interesting legally, interesting factually. So more
It's such
information
an
to
interesting
follow.
case.
Yeah.
I mean,
And I would imagine that the case will, as a practical matter, influence charging decisions in Uvalde, where of course the situation is a lot different because it isn't just one officer. There's a whole bunch of officers who did nothing, even as they had all the body armor and equipment and shields and riot
it
things
was
and
like
everything.
300 cops, and an
It was a
airsoft
lot.
team could have taken that guy out.
Yeah. So I imagine that the trial will be influential in charging decisions. Personally, I want to be elected prosecutor of Uvalde and charge literally everyone and let God sort it out. But they haven't elected me prosecutor yet, so it's very sad for me.
Yeah, I've got that. I've been finding that one to be a difficult case, just because I'm like, I don't know that legally they're going to get the conviction, but I still feel strongly about it in terms of morally. So
I may not get the conviction, but damn it, I'll feel better for trying.
yeah, I mean, I don't know. You just kind of look at something like that and you're like, you kind of feel like, why wouldn't you go in, right? So
yeah, well, I mean, the situations are kind of different. One guy acting alone when all he has is his uniform and his pistol and no body armor versus 300 cops who are sitting around in the hallway, fully armed, ready to go. And there's the famous video of the one guy going over to cleanse his hands with some Purell. It's like, we got to fight the germs. Can't fight the bad guy with the shots. I'm like, okay.
Oh,
great.
man. Yeah,
So hang on, I've got to hold my beer moment because I'm going to start spinning this thing and I need to explain what I'm doing because it's like a hold my beer moment.
Okay.
So this resin part chunked out because it wasn't cured properly, and then I've got a chunk here. So I'm laying pencil lines to know where I need to go. I'm going to try and add like a cool curve to get rid of the resin chunks, but still keep the blank without totally scrapping this. So if this goes flying, just know that I'm wearing my eye protection.
I was going to say, hopefully also like a face shield.
I will grab that now.
Yeah, the chip shield is a good move on this one.
I'm going to go do that.
Yeah.
Because the chat would be very upset with me if I allowed you to damage your face, because the chat is very attached to your face.
Maybe it could be improved. Maybe he could do a whole Phantom of the Opera thing. One face cursed to live under a mask forever. Could be a good luck.
I suspect that I suspect that would not please chat. Those chisels look very expensive.
Yeah.
Who's got 911 on speed dial?
Is Alita still there to offer aid?
No, I think she's left.
I'll go look up Rob's address. I know I have it somewhere just in case.
I'll dial 9-1, and then if there's a disaster, I'll dial the remaining 1.
Yeah. So yeah, really interesting case. It'll be interesting to see how it pans out legally and pans out factually. So they have not so far made their prima facie factual case because they haven't really been able to say what the defendant did. If he hid behind a car for 40 minutes and they have video of it, that'd be really helpful. They keep saying they do. Anytime they want to show it, be fine.
Yeah.
Yeah.
I kind of feel like that would be the thing to lead off with.
Maybe. I mean, there is the idea of recency and primacy. So maybe they prime them with the emotion to get them really heavily involved. And if it's their best piece of evidence, maybe it's what they finish with. I don't know. We're seeing. Right now, they're kind of spinning their wheels because no witness has added any information for a while, at least as far as I'm concerned.
I think I probably would have started off with that, with the, if you've got, let's assume they've got a video of him cowering.
Yeah.
I think I would have started off with that and then gone to one of the emotional clips of the, like here's the recording of the, the kid screaming.
Yeah, maybe. Different trial strategies. I don't know what's going on right now, and but the defense. But what I will say is, regardless of the strategic considerations on tactics, I've really liked both sets of attorneys, which I know is an unusual situation. The defense lawyer kind of completely poached the open, but on
His
the
open
actual
was bad, but after that, he seems to.
yeah, but he's a rock star. Like on both direct, the state has been fantastic. On cross, maybe sometimes he gets a little overexcited, pushes the envelope a little bit. Sometimes he asks the same question until they eventually say asked and answer to make him move on, to make sure the point's really hammered home. Sometimes gets a little excited. Sometimes testifies a little bit so much, but he's basically textbook overall. So I've been super impressed by the questioning of both the defense lawyer and the state, which it's nice when you have two sets of competent lawyers. So that's nice.
Yeah, I always feel bad about these trials when you see like defense or the prosecution are just screwing it up, or where they're greasy. Like
state hasn't been greasy. State has not been greasy.
They haven't felt greasy to me. I mean, they've been feeling like they're relying on emotional appeals.
Yeah,
but that's different than the feeling of grease that you get out of like the Rittenhouse trial.
Yep.
Where it was like, oh, I don't like this. Don't like this.
Yeah.
So, yeah.
Well, the judge has been mostly fair. The defense lawyer does tend to irritate the judge a little bit sometimes because he keeps having to whack him back into place. I think the defense lawyer might be doing it deliberately, though. So,
yeah,
maybe force the state to object, make it seem like they're trying to hide something. I don't know. Maybe there's
that's a dangerous game because if the court eventually decides to hammer you hard, then you've been asking for it the whole time.
He's already been whacked in front of the jury twice. Of course, there was cameraman just exposing faces of the jurors. I don't know how that panned out. So,
oh yeah, that I also haven't liked in some of the trials where
court like, TV there's the jury. Playing some dangerous games.
I mean, I like some of court TV's coverage. Sometimes I see what they're up to with their cameras, and I'm like, ooh, they're asking to be put on fixed viewpoints. Like the Paltrow trial.
I was like, they're fixing to get in contempt. I'm like, you want to see a judge uncivil lose his shit. I'm like, this is a pretty good way to do it. Cameraman, it's like, what are you doing tonight? Try again. No, you're not.
Yeah. What's your second guess?
Yeah. So, but the judge seems to be keeping his cool. So, okay, fine.
The what is it? The Paltrow trial. I thought the judge might just go absolutely, because they're like, oh yeah, we won't film the parties, and then they're like always filming the parties.
Yeah.
So, but the jury, like the parties is one thing. The jury's another thing entirely.
Yeah, that's a big no-no. It's been a big no-no since the mid-'60s. So.
Yeah. Well, especially on a case
it's only been the law for 60 years, no big deal.
Well, in this case, is so contentious, right? Like, let's say the jury acquits.
Yeah.
And right now, I mean, unless they saddle up and get a little bit, get some proper evidence in, that might well be the case.
Yeah, that's a very possible outcome right now.
People are going to be pissed at the jury.
Yeah. Have you talked about the Trump indictment, or are you skipping that?
I don't know. I mean, the problem with the Trump indictment is that whatever I have to say, people are basically going to be like, shut up, Canadian.
Well, I've covered it on my channel. So the Too Long Didn't Watch is Trump is in serious trouble this time around. So
I read over it and I was like, this is concerning.
Yeah.
If I'm defense counsel and I see that these are this is like the details against my client. I mean, none of it is evidence yet, but it hints at evidence, right? It tells us that evidence is on its way. But the problem is no matter what side I take on that, people are going to be upset and are largely going to be like, shut up, Canadian. So I will leave the U.S. political, landmine to the U.S. politicians because
Fair
or the
enough.
U.S. Lawyers on that one because.
Yeah.
But I mean, you're welcome to give your thoughts on it. I'm just gonna sort of hedge my opinion.
They apparently have this recording of Trump at a time when Trump knew he was being recorded. So like he was being recorded, I think, for like a book that he wanted to be recorded or something. And this whole conversation where he's having this conversation with the author of the book. And like he knows the conversation is happening. And he just basically blows apart every possible defense he could ever have. He's like, hey, look at this information. It's a map of the invasion plans. I could have declassified it when I was president, but I didn't. But I didn't. But I could have. But I can't now that I'm no longer thing. But it's still secret. It's still classified. So, you know, it's like, okay, so basically you are admitting to knowing it's classified. You're admitting to showing something you know to be classified to someone who's not authorized to be classified. And you're admitting to the fact that you didn't declassify it. So basically you just shot every possible defense in your foot in the space of 2 sentences. That's great. Thanks a lot.
Yeah.
Thanks, Trump.
As a defense lawyer, like when I saw that, I was just like, oh my God. Why?
Yeah.
It was like this statement that's just I'm looking at it going like
it is basically yes, I did the thing. I did it purposefully. Wah ha 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 ha. You know, that's basically what it boils down to. Okay.
It's basically like if the prosecution could write a statement for the accused,
yeah,
like
please
any
say these words.
statement
Please
to
say
put
these
in
words.
their mouth. Yeah, that's what they would put in. So
it'll be interesting. Trump's only saving grace is that the judge that's currently assigned to him was appointed by him. So we'll see how much that buys him, but I'm not super hopeful.
The thing is if that judge takes a step there, then we may see the.
Oh yeah, we'll see if the government wants to move to reassign it, but
yeah.
I think at best he buys himself some time, but he can't buy himself enough time. He can't buy himself all the way between now and the election. Feds don't roll that way.
And somebody was asking what I think is an interesting question. They were saying, can he still run for president if he is convicted? And the answer is yes.
Yes. Yes, which is hilarious.
You might be surprised to learn, but like, what's his name? The guy who did the shooting in that were, for this case. He can run for president if he wants.
Yeah. I mean, it's U.S. versus the U.S. term limits versus Thornton. Basically establishes the principle for Congress and in this particular domain for the president, it's exactly the same. All the criteria to be a member of Congress or for that matter, the president are mentioned in the Constitution. And those are all the requirements. So he meets every requirement. So yes, he can run and win and then pardon himself, which is hilarious.
So the one person who can't run for president is me. I haven't been convicted, but I'm a guy who's not born in the U.S.
I know, it's very sad.
It is because, otherwise I was totally going to win.
Well, maybe you could run for prime minister and fix your own godforsaken country.
Oh, I don't think that's likely.
You're not Fidel Castro's son. You got that working for you.
The problem with politics, though, is if you win, then you have to spend all of your time with politicians. And that's like, hey, why don't I sentence myself to misery? So...
Because you're a patriot and it's your civic duty.
Oh, yeah.
True North, strong and free, baby. Let it ride.
I don't think the world is ready for Runkletarianism.
Okay.
It's Runkletarianism is it's the way, but it's the world is not yet ready. So, but yeah, no, that's it's going to be a mess. This whole that whole indictment.
Oh yeah, that much is sure. I mean, that much is for sure.
And
and it obviously increases the temperature of such things, no matter how it pans out.
Yeah. Well, that was one of those things of like, if you're going to pull that trigger, you better not miss. And I think it'll be really like if they don't have the evidence they say they have, that'll be
yeah, I know people will probably disagree with this particular assessment, but I personally have a lot of confidence in the DOJ in the U.S. Attorney's Office, they tend to be pretty straight arrows. Every once in a while, they definitely go off the reservation, but I tend to take what they say at face value because most of the time it can be relied upon. So they definitely get it wrong sometimes, but I read the indictment, I'm like, yeah, that's probably all true. Yeah. So I have a reasonably high assessment of the DOJ.
Yeah, I mean, we'll have to see, but it's definitely a don't miss scenario.
Yeah.
But yeah, that's its own headache. And what do you call it?
I should schedule my stream for tomorrow morning while I'm thinking about it.
Oh yes. Are you using Midjourney for thumbnails?
No, I've just been using the same thumbnail each day for this Parkland trial. Just one of the shots of him in the courtroom with a suitable overlay.
Oh, nice. Yeah, that's a good strategy there. And now that Rob is wiping that down with, I'm guessing, a solvent, you can see the epoxy and sort of how that looks. So that is going to be a very pretty pen.
Yeah, sure. So this will be 6:13 in the morning. 6:13.
Oh, that's terrible.
What is
that? Yeah, that is an unpleasant time of day.
That's all right. This is 8:15 my time, I think. So you can redirect your stream my way when you're done. Cool.
Will it? Won't your morning stream be like way? I mean, I can.
Do you have anything better to do with redirecting tonight?
God, no.
Okay, then you can redirect it to my stream for the morning. 8 hours from now.
That works. I kind of suspect that people aren't going to be
well, they can
8 hours.
They can hit the like button and like, comment, subscribe.
There you go. That is a good purpose. Add. Is it up?
Should be.
All right. Uncivil. Where are we going? I'm not seeing it.
No.
Am I added to your list of people who can redirect?
I think I added everyone, actually.
Oh, there it is.
There you go. See? Yeah.
There we go. Save changes.
Live in 8 hours. There you go.
Yeah.
So you can check that out in the morning and see how it goes. It'll be interesting.
Yeah, I've been watching them largely on like Replay Crew. Because I downloaded your one from Thursday to watch Friday when I was on the plane.
Cool. Well, I hope you enjoyed it.
Yeah. Well, I also ran it while it was overnight, so it was like, all right, there we go. Got to make sure it's got the
yeah. For those asking for conversion from European time, it would be 9 hours from now, whatever your time zone is. So 9 hours from now.
So yeah, it's world is getting to be a weird place. I hope that none of that stuff really blows up, but we'll see.
So what else you want to talk about? We talked about Parkland, we talked about Trump. What else is on your mind?
Did you see my rage against a cycling study?
No.
All right, let's talk about the cycling study because it is stupid. This is not law. This is just thinking. Because thinking is
thinking is good.
Life skill.
Thinking is good.
So, study finds cyclists wearing helmets perceived as less human than those who don't.
Well, I mean, in so much as a helmet would block your features and make you not as recognizable as a human, I guess that would make sense.
So this is my rant because this is the worst possible study that you could ever imagine. So here we have the study. It's by a Mark Lim and a Sarah Collier, and apparently this is peer reviewed. But they said 30% of respondents considered cyclists less than fully human, which is actually not what their study can say at all. Cyclists with helmets were perceived as less human than those without. Cyclists with safety vests and no helmets were perceived as least human, and dehumanization. So you know how they did this? They got a survey of 563 people comprised of 2 paired alternate force choice questions to identify which image of a cyclist respondents considered to be less human. So you get 2 pictures of a cyclist and you have to pick one that is less human. There is no more human option. Like, there is no equally human, and there is no like comparison where there isn't a cyclist. It's all cyclists. So however people decide this, they're deciding that a cyclist is less human. The pictures are also sort of barely showing cyclists, and so this is her insect scale, which is a different, what is it?
What is 8? What is 80?
That is like some sort of bug man, I guess. But they're saying because people will determine this order of more to less human, then it also works on cyclist pictures. You want to see the cyclist pictures? Let's see the cyclist pictures.
That's an insect scale. How are humans insects?
I don't know. So these are the pictures, and like cyclists, they're like holding a bike. That's it. So they go from no headgear to hat to helmet to vest, and then they also tested this one that they didn't actually include in the results of person in like full racing gear. So yeah. You might be wondering, did they get like a random sample? No. This is an internet survey of just whoever feels like they want to participate. And over 70% of their participants said that they were that they cycled at least once a week. So it's a bit of a skewed sample because I'm guessing this was distributed amongst cyclists. But yeah, this pissed me off because it was shared by people who should know better. And it is an absolutely stupid study that does not show what it means to show. And it's kind of an example of, 66% male of their survey respondents, which kind of suggests we've got some skew on this. 40% or 44% were making over $120,000 compared to 26% of the population. So you got some interesting skew on that as well. Cycling frequency, 5 to 7 days per week, 29%, 3 to 4 days per week, 27%, 1 to 2 days per week, 18%. And you see the actual population itself on the side. At least monthly is 17%, 32% less than monthly, 40% not in the past year. That one pissed me off because it's such a bad study. It's just, but what they wanted to do, here's where the study gets even worse. What they wanted to do was use the dehumanization result to show a correlation with bad driving patterns. People who view cyclists in this particular way drive worse. And they got no results on that, on what their original goal was. So instead of calling it a failure, they just said, oh, well, we're just going to report our results of the things we forced on the data.
I guess it kind of makes sense if you ask someone like, is this person wearing a helmet more or less human than a person not? Because I suppose the extra things are augmentations.
If you have to pick one, people are going to make a choice. But
I don't know that it really proves anything.
Yeah, it's
The study hurts my brain parts.
Yeah, it's real bad. We also have this in the news that surprised the heck out of me. RCMP union tells Ottawa to stop making Mounties investigate colleagues. So the National Police Federation.
Who would you like them to? Who would you like investigating them?
Well, what happens is that when a member of the public makes a complaint with the police, they make that complaint with their local department, and then the RCMP decides if that complaint is justified.
Yeah.
And as it turns out, when police are investigating police, they don't find many of these complaints to be justified.
Yeah.
And so the public is understandably a little pissed off about all that.
Yeah.
So yeah, the public always sort of notes, they're like, hey, what the hell? And so yeah, this might actually get changed.
Excellent.
So critics have long argued that this process isn't truly independent. So they're actually looking to change this process. I didn't think I'd ever agree with the RCMP on anything, but I agree with the RCMP on this one.
The RCMP's favor of changing this?
Yeah, the RCMP union anyway.
Wow, that's surprising.
It is. And now I don't know what they're going to do to make it fully independent. I suspect they will set it up with like retired police members and so forth. But yeah, that is what it is. Somebody's asking, do we have the world's worst game show tonight? We do not. I don't have a cop or not a cop today. So have you seen that one? It's a sequence I do sometimes with the world's worst game show. And it's the worst game show because you can always guess the answer, which is that there's still a cop.
Yes. Yes. That sounds very, very right.
All right, let's get to some super chats here. So I've got Angie Torres. Thank you for 5 more gifted memberships. Missy Didi Moo saying always the best start to the week. Mondays kind of suck, so I try to make them suck less. Sardinisms going Z. Thank you for the Monday stream, Runkle. Have a good night, Sardinisms. Emma Z. Thank you for 5 gifted memberships. And Canonical Heat. Thank you for 20 gifted memberships. Much appreciated. That's fantastic. And oh wait, I should do a swoop. Swoop.
But I do have to push the button. Push the button. Yeah.
Push the button.
Yeah. Changes my background colors.
Ah, that is a good button. I need to get some of that set up. So
it's my shtick.
Somebody says, am I going to cover the MPP who pretended to get punched in the face? Not yet, because did you hear about this one?
Is it the one who spit on somebody or?
No, this guy posted on Twitter. He said, I was at a pride thing and I got punched in the face, but I'm happy to take a punch for, LGBT people or whatever else. And so he got an outpouring of support, people going, yeah, that's great. And then later somebody, and ironically, the person who posted this video is pretty left-leaning. She's just taking she's taken to like videoing protests.
Mm-hmm.
And she's got video of this guy holding his megaphone, and the megaphone has like a little hook on it, and the hook is digging into his face in exactly the place where he says that he got the mark. So a lot of people are going like, did you get punched or did you just kind of, bump yourself with your own megaphone? That is still, there's a lot of argument over that, but it's not really a legal issue because he never, so far as I didn't see that he reported it to the police. So if he didn't report it to the police, then he can't be charged for making a false report. It's just the guy might be a jerk. That's about it. But if he did report it to the police and it's a false report, then he could get charged with public mischief. And I don't think he'd be punished very hard for it. So,
well, gonna commandeer your chat while I have you guys under my spell. For those of
There
you
we
who
go.
have, for those of you who have the Twitters, I just posted in chat a link to my stream for tomorrow. So if I could kindly ask you to please retweet the link I just posted in the chat. If you click on it, it'll take you to the Twitters, and if you hit the retweet button, that'll be good. It will help very much spread word of my channel and help the channel grow. So I'm not beyond begging. Please retweet. Thank you.
Yep. If you your coverage on that's been great, so people should check that out. What is Rob doing now? That looks worrying.
I'm sure it's fine.
Oh, he's got a dampened. That's he's doing some sanding. It's moistened, so.
Yeah.
All right. The other sort of interesting
Is
thing,
Rob flipping us off?
of course he is,
Why?
because he knows I'm going to play the swoop. Because if Rob is doing moistening things,
Oh. You changed the audio?
I changed the audio because it was making Rob a little too upset.
I want the old audio. That was much better.
I could find the old audio, but it's the old audio was yeah. Some people don't like the slurpy noises, so I'll have to figure that out. People are saying I made it worse. Some people are saying I made it better. So if I use the other one, Rob won't play it. So people are saying old audio. Do I have the old audio handy? Will Rob just drop out of the stream if I put on the old audio?
You might.
Probably. He's like, maybe. This is kind of like, what is it? Cousin It from Adam's Family. We've got this hand communicating. It's so
You could just translate thirsty into multiple languages and just have the word thirsty just repeated over and over again in different languages. So translate to French, Spanish, German, and just that would be the audio. The word in multiple different languages. Use Google Translate or something, get the audio in different languages.
Did you also hear about Canada seizing a Russian cargo plane?
I did not.
So there is no court filing about it yet, but Canada is trying to seize a Russian cargo plane and give it to Ukraine.
Okay.
So this plane got stranded at Pearson International Airport because it was a Russian plane and couldn't fly anywhere. So the government then declared that they were seizing it. And they so there's going to be a court proceeding, but nothing's been filed at this point. And so, yeah, this I think I can bring up the
Why can't it just fly back to Russia?
well, because Canada apparently wants to declare war or pick a fight. So that's the plane apparently. And yeah, we Canada is trying to claim this and give it to Russia. Now, it's not actually clear if this is allowed under international law. And that as a result of doing this, Canada might end up in a situation where like other Canadian assets get seized. So,
I mean, I don't imagine that would happen in any event, to be honest.
Yeah, it's and this is apparently the second time Canada has issued one of these orders to seize things. The first time was $26 million held by a capital company. They said, we want this. This is ours.
Hmm.
So it's going to be a wrinkle on this one. Especially because this, like, the owners of this plane are subject to sanctions. And because they're subject to sanctions, they can't actually hire a Canadian law firm. So how does that work, that they would have representation? Yeah, it's a problem. We're going to see what's going on there. So
Yeah, this doesn't make a lot of sense to me.
Yeah, no, I don't understand.
Does Canada want to declare war on Russia?
I don't think we can win that fight overall.
No, probably not.
Like, I kind of feel that Canada versus Russia is going to be a short fight. So I am concerned. All right, let's get to the rest of the super chats. There's not a whole lot to worry about here, but Hardy tried to get the pumpkin to invest in his currency. Glitterblade lectured Lima about biting into a raw gourd. Rob weirded out by Pip It combo. I will have to check that out. That is Lawyers and Dragons recap. Torin3 saying, have to get some sleep, but wanted to thank you and Rob for helping push me to 740 subs. Got to do some CNC woodworking this weekend, so happy here. John Coman, my dad submitted a political cartoon to Playboy saying it's always good to have a second Bush 2004, and it was 2 Bushes. Cue thirst swoop now. I wonder if that one got published. If the judge allows this to go through, how much discovery are the cops subject to? This going to trial will give Afroman real facts for his next song. I don't know how much you could actually get from discovery on this one.
Yeah.
So, I mean, I don't know what facts he doesn't have that he'd want at this point.
What was your basis for thinking I was guilty of kidnapping would be nice?
Yeah. I mean, who knows, right? Because it looks like somebody said that there were women held in his basement. That just seems odd.
This just seems to be the thing that we're doing now. It's just accusing men of holding women in their basement. Andrew Tate, Afroman, just whatever. Just apparently that's what we do now.
Well, Andrew Tate, I mean, some of the statements he made himself were pretty terrible. So we had Andrea should watch the.
He tries to say shit though. He tries to be very provocative. That's his shtick.
Yeah, I mean, the problem is if you are trying to be provocative and you say things that might be crimes, then you might also get charged for the things that you said.
Maybe.
It's a dangerous game, right? Susan, thank you very much for the $5 super sticker. Much appreciated. Equality, yay, Andrea's awesome. Thank you both for always being the voice of reason.
Andrea Burkhart?
Yep, she was on earlier.
Most underrated lawyer on the law tubes by far.
Oh, absolutely. And I mean,
if I had one lawyer I'd want to work with, it's Andrea. That'd be fun.
Oh, absolutely. She is. Well, and if I got in trouble in the States, it'd be like, help. So, hi, please check your email. Tinkerbell's attorney has filed her defamation complaint with the court. Apparently, this is what I do on Monday nights. I will check that later, but I was saying Tinkerbell was not real. So
Tinkerbell exists as long as you don't believe in her. So the very act of you saying she's not real decreases her livingness. Ian, clap if you believe.
All right, uncivil is.
Live, Tinkerbell, live. Don't listen to the mean Ian.
So I was on hold with WestJet for over 7 hours and was woken at midnight, lulled to sleep by hold music, to find that she couldn't help me. Ridiculous. WestJet is a terrible airline, and they're miserable. Jessica P., thank you for the new membership. Much appreciated. Talia E., weren't we going to have Kurt congratulate the Dred Scott lawyer with the LSAT score? Are you familiar with the Dred Scott lawyer?
This is the guy who published about his thing in the newspaper?
Yes, and also filed an affidavit with his
With his family tree?
With his family tree and his LSAT score, and also cited to Dred Scott.
Just out of raw curiosity, how's Dred Scott get into this?
So his argument about why he should be able to have a machine gun is because he says that there's groups of Americans with special rights, those that are descended from the founders. And so he files his family tree to say he's one of those people. And he cites Dred Scott for the proposition that there are some Americans with more rights than other Americans.
Okay.
Now, it is worth noting that I was briefly banned from Uncivil's Discord for asking him to do a video on Dred Scott. That is how bad Dred Scott is as a case. It's real bad. It is generally considered to be like one of the worst decisions of the U.S. Supreme Court of all time.
No.
Never explicitly overruled, though, because
Well,
no one thought they had to.
there were the 13th, 14th, and 15th Amendments, so there was that.
Yeah, I mean, I feel like some case should just go out and explicitly say, by the way, Dred Scott is no longer good law.
I don't know that you can really do that. They tried to do that with Korematsu in a throwaway line. And by the way, Korematsu's overruled. And I'm like, technically that's dicta. So I'm like, okay, well, we tried at least.
They need it to be relevant somehow.
Well, you need to have a case that's on point. What's the scenario where this is coming up?
Well, you might have some crazy guy with a 173 LSAT who is trying to fight this case.
Okay.
So, yeah. The thirst sound should be the sexy saxophone from Careless Whisper, but played badly on a recorder.
It could work.
Could work, but I think getting the rights for that would be difficult. 9 Inch Nails gal, thank you for calming my brain. Productive morning. I was productive today, so that was good. I've got written submissions coming due, which sucks. But I got about 8 pages written because my attention deficit is not being super helpful. And it'll probably end up being about 20 by the end of it. So it's on a certiorari application. So, and it's gun related. So yeah.
We could show up with our guns at the Canadian Supreme Court, see how that works out.
No. I see. People are saying that they needed you to congratulate Mark J. Blunt on his 173 LSAT score.
That's okay. Voice. That's okay. Blackleaf has no interest in congratulating Mark J. Blunt.
You see that? You're below Blackleaf status, Mr. Blunt. I've been having fun trolling this guy on Twitter, although he hasn't yet responded. I suspect he may have just muted me, but he keeps posting about all of this, and I'm like, wouldn't they need somebody with a better LSAT score? You only got a 173, sir. Because
99th percentile. I mean, it's pretty good.
I beat him. It doesn't matter, but I beat him. So the only reason why it's funny now is because he thinks it matters. Yeah, it's like if he filed his dick size and it was. So, yeah.
Why don't you tell us what dick size yours would beat, Ian, while we're completing this analogy?
Hard pass on that.
That's what she said.
Oh. All right, now I'm blushing. And there's Rob with what is not a size comparator. That is for a pen.
Oh, you got a penis, my dear. I've been looking for one for years. That's an old SNL joke.
Back when SNL was funny?
Yeah, back when SNL was funny.
So, sadly, some years ago. Well, I've been at this for about 4 hours, and I still have legal writing to do.
Excellent. I need to go to sleep because I need to be up in 8 hours.
I'm going to tell you, I'm probably not going to start watching right when you start, but I will catch up. I'll start when I when I can, and I'll run it at 2 times speed in order to catch up.
Cool.
Guys, check out Kurt's coverage of this. It is it's good coverage. He's got good insights into when the lawyers are screwing up, what evidence is useful, what evidence isn't, because it's and Rob will actually tell you, or sorry, Kurt will actually tell you useful things about the case. Whereas if you're watching the sort of mainstream media coverage, they will not.
No.
Sadly. All right. Good night, everybody. Rob, did you want to say?
Hang on.
Oh, Rob's saying hang on so we can get in a goodbye.
Saying bye. Thank you guys for tuning in. Sorry I wasn't more active, but I was just
it's all
having
good.
some fun.
Oh, shop time is important. So let us roll the outro here and see everybody next time.